Lwazi.
Hello, good morning, honorable members. Good morning, honorable minister and deputy minister. Are we all on board on the platform?
Yes, Chair, we are on board on my side.
Thank you. Thank you, Nyamboso.
Good morning, Chair. Good morning, members.
Good morning, Chair.
Good morning, honorable members. Good morning, support staff.
Good morning,
Good morning,
Chairperson.
Chair.
Do we have the necessary quorum to start the meeting, Lwazi?
Good morning, Chairperson. Yes, we do have a quorum, Chairperson.
Okay. Has the minister been able to log in?
Good morning, Chair. Minister did submit an apology, Chair, and the DM has submitted an apology, Chair. Thank you, Chair.
Okay, thank you. Good morning, honorable members. Good morning, DG and your team. Good morning, and also interested stakeholders that actually have requested to join our meeting. I just do want to welcome all of you to our meeting. Before we go any further, I would like us to look at the agenda and adopt it. Honorable members, would you like to add or subtract anything on the agenda? If not, can I recognize a hand to propose for the adoption of the agenda?
Honorable Ndalane propose the adoption of the.
Thank you, Honorable
Propose the.
Dalane. Yes.
Yes, I propose this in the adoption of the agenda.
Thank you. Who is the seconder? Who can I actually recognize the hand for the seconder?
Chairperson, my hand is up. Honorable Adams.
Thank you, Honorable Adams, for your secondment. And the next item would be the apologies.
Good morning, Honorable Chair, honorable members. Chairperson, as I've stated before, I did receive an apology from the minister who's attending cabinet and from the DM as well, who is also attending cabinet. Honorable Mahlatsi is on oversight in KZN. Honorable Mutama is attending the impeachment committee. Honorable Maseko, she's currently attending Human Portfolio Committee on Human Settlement. Another chairperson, we have a new member, alternate Honorable Van der Walt. She is attending the meeting, Chair. Thank you, Chair.
Thank you. Thank you very much, honorable members and the DG. We meet today to consider the ongoing implementation of the labor tenant program. against the backdrop of presentations received from Legal Aid South Africa, the Department of Land Reform and Rural Development, and most recently, the Special Master of Labor Tenants. Nearly 3 decades after the enactment of the Labor Tenants Act, approximately 8,913 labor tenant claims remain unresolved. I read in this in the report that at the current rate of progress, it would take about 10 years to settle these claims. We thus need to think creatively and implement decisive corrective measures. We are going to focus on progress, court referrals, and case management processes. The question for the department is how to unlock the bottlenecks and translate existing frameworks and legislations into meaningful outcomes for the claimants. Today, today's engagement must actually therefore focus on accountability, solutions, and measurable progress. The committee requires a clear understanding of the true scale of the backlog, the obstacles preventing faster resolution of claims, and the special actions each institution will take to accelerate delivery. The committee approaches this meeting or even this matter with the seriousness it deserves. There are specific matters such as the Nkambule family matter and the Mkwanazi matter in Mpumalanga, which have been in our books for a long time. We look forward to a frank, constructive engagement that places the interests of labor tenants claimants at the center of our deliberations. I now invite the delegation to proceed with its presentations as follows. I would request the department to actually first do their presentation and then followed by the Legal Aid South Africa, and lastly, the Special Master of Labor Tenants, Professor Lavin. I would plead that we follow that kind of sequence. I thank you, honorable members and honorable DG and your team.
I'm sorry, Chairman.
So yes.
Sorry, Chair.
Yeah.
If I may.
Yes.
Chair, I think we missed an important step in the management of a meeting. Lwazi has presented apologies. Amongst those apologies are both of the minister and the deputy minister.
Yes.
It's customary in this committee that when apologies are presented, members are given an opportunity to ventilate on them. And I think with your indulgence, Chairman, I would really want us to uphold that tradition. Thanks.
Thank you, Honorable Nana. My apologies. It was just an oversight. I thank you for drawing our attention to that very important aspect of our agenda. May I therefore call upon the honorable members to reflect on the apologies that were presented to us. I'll recognize hands.
I'm on my cell phone, Chair, if you will allow me.
Yes.
Yeah, thanks very much. And morning, members, morning, colleagues. I'm sorry. My voice is a bit hoarse this morning. I've got a bit of flu. Chairman, we've been here before, and we have deliberated on this issue. We all know that cabinet sits on Wednesdays, and as the committee, we've raised our discomfort with regards to the absence of the minister, the deputy minister in our meetings. There has been an improvement, I must say, particularly from the side of the minister in trying to attend our meetings. Today, we are to receive presentations relating to labor tenants. And if any one of us bothered to glance over those presentations, I'm sure members will agree with me. The story is not so good to tell. And here we are, about to engage in a very important topic, which actually requires political will. And having glanced through those reports, Chairman, I get a sense that there is nothing much that is actually moving, and there is a lack of a political will to ensure that, amongst other things, the Office of the Special Master is fully capacitated. The issue relating to the under-resourced or underfunded legal aid are addressed. And those things really require political responses from the minister, either the minister or his deputy. And here we are, once again, both the minister and the deputy minister are not here. The DG is hardly a month or 2 months. He's new. He will rely on his DDGs and his other colleagues. We have resolved in the past, Chairman, that critical reports or presentations such as this will not be entertained in the absence of either the minister or the deputy minister. I just want to put it out there that I actually, if you ask for my proposal, I'm proposing that this meeting be shelved until the minister and or his deputy are available. Thank you very much, Chairman.
Thank you so much, Honorable Nana, for your contribution, which I think is very, very important, because it reminds us of where we're coming from insofar as the issue of the attendance of these meetings by the executive is concerned. So I would allow also other honorable members to have an input. I'll recognize hands. Is there any hand that is being raised? Can Lwazi help me to identify hands if there are any?
Honorable Shelembe, Chair.
Honorable Shelembe. Honorable Shelembe, you have the floor.
Thank you. Thank you very much, Chairperson.
submitting my concern as well, and also support what Honorable Lindy has said. Chair, decisions are very important, but there are people, especially members of the executive, that are responsible to ensure that decisions taken are implemented. So whatever we discussed here in their absentia will mean it's like they don't know unless if we have an ambassador to go and speak to them, whereas we do not need someone. We want to speak to them directly. Chair, looking to the importance of these matters here, especially where, as you have indicated earlier, that about 113 outstanding land claims hasn't been finalized. That means now also your statement that it may take maybe also 10 years. That statement alone needs the presence of the minister to tell us what is that they intend doing to ensure that the implementation is not delayed any further. Also, when you look the issue of the budget that the legal aid South Africa is faced with, it tells you that something must be done. If a position has been frozen and also because of the budget cuts, that means the high profile leadership, that is the minister and the deputy must be in the meeting to help us so that at least we know what is going on. In short, I want to second that the meeting is postponed until the minister and the deputy is available so that we are able to engage directly with them. The reason for this meeting is to engage especially with the executive. Thank you very much.
Well, thank you. I will welcome the further contributions from other members as well.
Chairperson, I've been raising my
Honorable
hand.
Isaacs, Chair.
Honorable Isaacs.
Good morning, Chair. Good morning to the meeting. Chair, I've been raising my hands, and the reason why I'm raising my hand is not to differ with anyone and not to agree with anyone, but just to put the reality that we've been sitting with this challenge for a long time. It is a fact that Cabinet is sitting on some Wednesdays. Other Wednesdays, maybe particularly in the last time the minister have been trying to be available. But what is also a fact is that we are busy discussing very important issues that is having a serious impact on the success of our democracy, particularly in ensuring access to land for our people. So what I would love us to consider is how do we meet each other halfway with the members of executive to make sure that they are there to account, taking into account that we have been told and we have known that we are actually placed on a time that coincides with cabinet meetings. And I'm just wanting to be very realistic. I don't want anyone to fight with me for my views. I just want us to see whenever we are having issues of this nature that will really need the ear of the executive to be able to attend to the issues that we recommend. We will have to see how we meet each other halfway. I don't have a proposal. I just want to say that we must be realistic in whenever we are deciding on someone. Lastly, I won't agree that we postpone our meeting because of the fact that the minister is not available. The minister should have made arrangements for someone to be here to make sure that they record whatever we are discussing so that it will be able for him to report back on the issues that is being implemented. Thanks, Chair.
Well, thank you, Honorable Isaac, for your input, which actually is pragmatic and also looks at the reality of the situation that we operate under. Honorable members, you will bear with me that indeed it is true that this matter has actually been discussed over and over again in previous meetings. And as Honorable Nana acknowledged, that there was, after that concern was expressed to the minister, there was some kind of improvement. But yeah, we will never stop trying, because the reality is that the minister is actually in cabinet. And what is worse, there are cabinet committees that also include deputy ministers. And in most cases, those cabinet committee meetings actually also take place on a Wednesday. So we really need to find a middle ground that will actually be considerate of the situation and environment that we actually operate under. But I agree with Honorable Nana. We honestly cannot compromise the progress of our work as this committee by allowing the absence of the executive on a perpetual basis, because we are not going to get anywhere. At the center of our activity is accountability of the executive to Parliament. And we represent Parliament, and we have to hold our executive accountable. The issues that we are going to be looking at today, they really honestly require the intervention of the minister and the executive as a whole. I did mention, a few cases. It's now almost a year that we've been to Mpumalanga, and we raised the issue of the Gambule family and the Mkwanazi, and other issues that we came across in Mpumalanga and elsewhere. So we definitely need to get progress that has been made on those issues. But be also mindful of, we are mindful of the issues that Honorable Isaac is actually raising, that we need to find a way to navigate our way through in the midst of all these impediments that are actually, facing us. I was wondering if there is any. I will allow the last one last member to express a view in the light of the proposal that actually has been put before us. Is there any other hand?
Honorable Mkhaga, and followed by Nyambose, Chairperson.
Honorable Mkhaga, and then Nyambose.
Good morning, Chair. Good morning, honorable members. Good morning, everybody. Because we know we debated this matter, and I shared the sentiments expressed by Honorable Nana and yourselves. It's a matter that we said the minister must raise with the cabinet. And also from our side, we'll raise this matter with the office of the chair of chairs. But it's clear that there's no one attending to it. It's a clash that we in these meetings without the executive for the rest of the term. And it can't be, we're a constitutional structure here. It can't be then that a minister would use his discretion to come to our meeting. mindful of the fact that he is found in a situation he has to divide himself. But there's no way that we can compromise on our work. In light of what is raised by Honorable Isaacs, because I don't want us to lose this Wednesday, because it's clear that from now henceforth, there will be minimal opportunities for the committee to engage because of many programs that are oncoming towards the local government election. We might not have time to deal with these matters. Now, how about honorable members considering that we meeting halfway? We target, we try to meet a minister after hours. And one of the items be this item again on the table. Suggesting 4 o'clock, assuming that the meeting of the cabinet would be out by then. This meeting was supposed to be 10 minus 4 hours, 3 to 4 hours. We'll try to navigate our way from 4 o'clock up to 6 o'clock or 7 o'clock. That's my proposal, Chair, because I'm worried, because if we lose this day, I'm not sure when. And the problem is that it's not about the minister, it's about our people resolving, it's about us resolving the problems of our people. And there's no way that we can resolve this problem without the executive. That was my proposal, Chair. Thanks.
Well, thank you, Honorable Mhaha. Honorable Nyambose.
Greetings, Chair, and greetings to honorable members and our officials as well. I think in the spirit of separation of powers, we are the legislature, the minister is the executive, and we have the judiciary. So in terms of timetable and scheduling of workload, we are fixed that we meet on this day. So we meet irrespective of the other arm of the state, whether it's present or not, because we have our own prerogative to meet. And if there is any decision we take in this meeting in the absence of the minister, that decision will be communicated to the minister. It will be on record in the history of the work of this portfolio that ministers have been invited, but they are not able to attend. And reasons of their non-attendance are obviously another arm of the state workload. This actually challenges the programming committee of Parliament with that of the executive programming to say it is now clear that we will always clash in terms of interest. Then those who do programming, they now need to know that always our work is actually affected by the work of another arm of the state. But our people need us to respond and hear these matters. We do have power to hear these matters in their absence. It is our desire that they be present. But if they are not, we are not immune from meeting. It will be known that the committee chooses not to meet because the other arm of the state is not present, which is not their job description and function. So let's continue with our meeting since everything is here. The minister, if he or they don't have a representative here, that is also their matter as to how they actually choose to do their planning. I'm sure there is somebody who is the parliamentary advisor to the or liaison person of the minister. That person must take responsibility, must be given powers. But here we are on a separate power issue, let's do our work and see where it takes us. We can't be held at ransom by another arm of the state. We don't account for them, we account for ourselves. On those bases, let's proceed with the meeting.
Chair?
Thank you. Yes, yes, is that Honorable Nana?
Correct, Chair.
Okay, you're on the floor, Honorable Nana.
Thanks, Chairman, for your indulgence. I want to second the proposal by Honorable Khaka, because it shouldn't come across as though we don't want to do our work. But in truth, we need the executive authority to be present. I think Honorable Khaka's proposal is sensible, that we adjourn today's meeting and we meet later on today in the presence of the minister or the deputy minister. Thank you.
I thought the DG would be in the meeting. I would be interested to hear his views on this one.
Good morning, Chair. DG is on the platform, Chair.
DG, I fully understand that this is a matter in the domain of honorable members, but I would value your input in the discussion that is currently taking place.
Good morning, Chair. Good morning, honorable members. Good morning to all stakeholders that are part of the meeting today. Honorable Chair, let me appreciate the opportunity to express a view on this matter. On the principle, no, Chair, we will be guided by yourselves, the members, on how we could move forward. However, from our side, we have engaged the minister. The minister is committed to the implementation of this program. We have developed systems and measures to improve the performance to a point where we have already agreed on a war room that meet on a monthly basis to track progress. We have appeared before the judge president, who gave us strict instructions and timelines on what needs to happen. We are meeting with the Department of Justice to deal with the issue of how do we strengthen the legal system, including legal aid, to improve the performance. So in our view, Chair, we would wish to continue if it's allowed, and the minister is committed to implement the resolutions that might be taken by the portfolio committee. Thank you, Chair.
Well, thank you, DG. I thank you so much for your input. Honorable members, I'm not in any way trying to play down the seriousness of the issues that you have raised. It is really indeed very serious that the executive must take the work of this committee very seriously. Yes, notwithstanding the clashes that exist in our programs. But at the same time, I am persuaded to want to continue with the presentations that already are there. I'm here thinking of other stakeholders that we actually have invited to be part of this meeting, and they made time to be present at this meeting and make contributions, one may not be aware of any other commitments that they may have after this meeting. So I am, whilst it is important that we do whatever it takes to ensure that the minister is here, but I was going to plead with honorable members to allow ourselves to continue with this meeting, receive the presentations now, and see if we cannot again organize I don't know what, or even a special meeting for that matter, on a Friday or this coming Friday on Zoom, and get the firm commitment of the minister that he will be present on that meeting and that he gives us, concrete answers and commitments on the issues that would have been raised at this meeting. That's how I feel, honorable members, that we, rather than postponing the current meeting, not knowing what the other stakeholders actually programs are for the day, might actually also create another problem of arranging a meeting this afternoon only to find that critical stakeholders are not able to be present because of prior arrangements. I don't know. That's how I feel. I would feel that we continue with this meeting and then go and allow talk to the minister about a possible special meeting on a Friday to actually get his firm commitment on the issues that the DG has raised.
Chairman,
Yes, Nana.
I can only be persuaded if you make a commitment as the chairman that you will write to the minister formally, express the committee's displeasure at their absence. Members, I've said this before, Nyambos. You teach people how to treat you. When they treat you exactly in the manner in which you have taught them, we have no right to complain. This thing has happened before. We stamped our foot down. Things improved. Now that things have improved, we're back to square one. What must we do is to step our foot down. That's my 2 cents, Chairman. Thank you.
Thank you, Honorable Nana. I fully and appreciate. I agree with you, and I share your sentiments on this matter. I honestly do. Well, honorable members, in the interest of time, I would actually give the last one just a minute to say something, and then we move on. I will definitely, Honorable Nana, write to the minister again, because I had written to him before. I had even engaged the House chairperson on this matter before, and that is why you saw some improvement. If it needs me going back again to the House chairperson, I will do it. And writing to the minister, I will do, because that is the consensus of the committee that that this be done, that the attention of the minister be drawn to the concerns of the committee insofar as his erratic attendance of the meetings is concerned. I will do that.
There's a hand, Chair. Apologies. There's a hand, Professor.
Okay. Can you take the floor, please?
Thank you very much, Chairperson. I'm assuming that it's my hand that is being recognized here. This is Richard Levine.
Yes,
and-
Prof. Good morning. You are on the floor.
Thank you very much for the opportunity. I would just like to emphasize that this program is a program where the three branches of the state intersect. Because you will recall the Constitutional Court judgment, which placed supervisory jurisdiction of this program in the hands of the Judge President of the Land Court, who has an agent who happens to be myself. And I would urge that we actually proceed, notwithstanding everything that I respect has been said, because I think that we are at an inflection point where the arrival of the DG has already changed the playing fields, recognizing the key collaborative role between myself and himself in order to drive this program. So I understand I will be given a chance to present the presentation if we do proceed. But it's important to state up front that in the last parliamentary hearing, I was asked, when looking at the targets that had been presented by the department, how long it would take. And I indicated on those targets it would take 35 to 40 years. And then I was asked how long I think it could be done. And I said it could be done within a 6 to 8 year period. We have discussed this matter with the DG. And that arc of 8 to 10 years is something that we are currently discussing, which would require a dramatic acceleration. So I think it's an opportune time for myself and the DG to make our inputs into this meeting should the meeting proceed. Thank you very much for that opportunity.
Well, thank you, Professor Levine. Honorable members, let's proceed with the meeting. I am making an undertaking that I will write again, excuse me, to the minister and express the concern of the concerns of the committee. Thank you, Honorable Minister. It was worthwhile that we actually utilize this time to express and ventilate our concerns about the executive. And just hope that besides my letter, the representative, the ministerial representative in this committee will take this message across to the minister. Thank you. Can I then invite the department, the Director General, to actually make a presentation? Thank you. Over to you, DG.
Thank you very much, Honorable Chair. Once again, good morning to honorable members. Chair, with your permission, may I ask Mr. Bongingosi Zulu to do the presentation? He is the Chief Director responsible for the implementation of this program. And I would also like to indicate that we have also DDGs that are present in this meeting. DDG Ndove, who is responsible for land redistribution. We've got DDG Letompa, who is responsible for all provincial operations, and DDG Lupungela, who is responsible for corporate support services. We've also got the National Program Manager of this program, Ms. Ngubo, as part of the team that is here, and the offices of both the Minister and the Deputy Minister, and lastly, our legal services. With your permission, Chair, may I ask Mr. Zulu to do the presentation? Thank you.
Mr. Zulu, you have the floor.
Thank you very much, honorable members, honorable chairperson, to the DG and the colleagues. can I request that maybe, because I'm trying to share from my side, I think I can't. Maybe Mr. Ralph can share the presentation for me from that side. Thank you very much, Honorable Chairperson. I am going to take you through the presentation and the next slide. With the guidance from the committee through the letter, we are going to deal with those items. One, a progress on the court-ready cases that were referred to court and their current status. Then the second part that we were requested to do was to assess and provide the committee with some insight around the administrative, legal, and financial and operational bottlenecks which are affecting the finalization of these claims, and then the measures that we have implemented to accelerate the processing and finalization of the court-ready cases for labor tenants, and then the issues around adequacy around funding for legal representation and litigation, and then the interventions to strengthen coordination, and then any other additional measures or policy interventions or resources that would be required. So those were the marching orders we got from the committee. In the next slide is just an executive summary, which I think the committee is very well versed with this, that these claims were lodged in terms of this act on or before 31st of March 2001. And I think what is important also to the committee is that the lodgement was not similar to the restitution claims, which were lodged directly with the department, with the Commission of Restitution of Land Rights. However, during those times, in the former department, this task was given to AFRA and especially in KZN, and in the provinces of Mpumalanga, like it was the so-called Transvaal, it was that track which was responsible for that lodgement. And those during the processing, unfortunately, what we have also noted, which I think is very important, was that during that process at the time, there was no standardized application form, which we called Section 16 application forms at the time. And then there's claims or applications after that process, the lodgement campaign by these two service providers, they were then handed over to the department for processing. Next slide. It's also important to note, which I think Professor Lavin has indicated, there was this Mwerase judgment which came in to deal with these issues of the outstanding labor tenant claims. And then the last bullet under our executive summary is just to also highlight what is very important in the settlement of these claims, is that they involve a structured administrative and judicial flow. Therefore, there are two ways of settling these claims. It's settlement by agreement between parties, where the other party, which is the landowner, agree or accept the status of labor tenants, which makes us then move faster as a department to settle that labor tenant. And secondly, is through adjudication through the DG in terms of Section 17.6 and Section 18.6 or subsection 7, where there is a proposal, but there is no agreement. In some instances, there is denied, straight right denial or rejection of these claims. What you will note, honorable members, in the entire backlog that we have, which is approximately 8,957, according to our records, the majority of these cases will only be resolved through adjudication by the land court. That is why it is very important for us to sort out the backlog that is sitting in court, which I will allude to, and also the new cases that we refer to court on a daily basis. And additional to that, the legal representation is critical as well in terms of dealing with those cases that we have referred to court, because the moment we have referred, the department have got no control over the court processes. I will also demonstrate the court schedule in the presentation, which I think the honorable members have gone through it. Next slide. In terms of the next slide, there are historic cases that were referred to court, which if we're talking about this, the labor tenant cases that are ready for court. One particular area, they are twofold. There are old, which we call historic. There are those that are new. The historic, they date back from 2013 to 2023, which were referred to court by the department during the time of the Department of Rural Development and Land Reform. And then there are those that we have referred, which are new. There's category 2 of them. I will give you the statistics in this presentation. But on the historic cases, we decided with the court led by the deputy judge president to do an audit. The national program manager spearheaded that process to audit all the cases that were referred to court, which are close to 2,000 cases from 2013 to 2016. However, then we appointed panelists. However, during that process, we managed to, together with the court, managed to audit approximately 600 cases that were audited. The national program manager is here in this platform, in this meeting. But however, the court said we need to put on hold because they were looking at the numbers that we have already audited. We audited from 2013 to 2016. And they have since then, from that audit, identified approximately 70 cases as pilot cases, just to test how we're going to deal with these cases. However, out of the 20 cases, of the 70 cases that were identified by the court directed that let's reduce it to 20 cases. I will give you the statistics of those 20 cases, where we are about them in the next slides. So currently we are working on the historic cases. We are only working on the 70, but piloting 20 cases, which we have dealt with. I will give you the status of what we've done to date. On the new cases that we have referred, since the appointment of the National Program Manager is 203, 302 new cases that have been referred to court. I will also give you the breakdown. Currently, we are sitting with draft referral cases of a total of 178 cases that we are working on this financial year until the end of March 2027. Next. This is the 70 cases that were identified by the court. We've done an analysis. They are in the majority of those cases are in KZN. They were referred to court. Only the ones that we have audited, the 70, when we did the analysis, they were referred in terms of section 33(2)A. which means those ones, according to the referral in court, are those cases where there was no Section 16 application. And the other ones were the 34 of the 70, the 36 of the 70 is where we have Section 16 notices, Section 17, Section 16 applications, and Section 17 notices were issued to landowners. And then they rejected, which are now whether referred to court. But what we have analyzed during the time when we did the analysis of the 32, which were Section 33A, 2A, we discovered that some of them, they are Section 16s, but erroneously, the attorneys then, they took them to court outside the department and referred them, which we have cleaned up. Next slide. In terms of the new cases, as I've indicated, which were referred from 24 until from 2024 to date, we have got 250. There are 302. They are broken down as follows: 250 of the 302 they were referred to court, and 250 were referred to NGI for geospatial mapping. In terms of the agreed enhanced land rights inquiry, which is linked to the referral framework that we have adopted with the special master. And then 199 of those cases of the 302, they have since been allocated to judges. I will show you the different judges that they are handling those cases under case management. 52 notices of those have been referred to provinces for serving to landowners, which are currently being served to landowners. As I've indicated, the 178 are currently new drafts that we are processing this financial year, which will be additional to the 302. So which will make about 400 and something that will be referred by the end of March 2027. The matters referred to legal aid, they are part of the 302. As we refer to court, we refer to legal aid to request them to allocate, to provide legal representation, or to allocate attorneys that will represent the labor tenants during litigation. 178, as I've indicated, versus what we have targeted for this financial year, is just the breakdown per province and the targets that we have in terms of our operational plan. Next. This is the breakdown per province of the 302. As I've indicated, the ones that have been allocated to the 199 of the 302 have been allocated to judges by the land court, 7 in KZN, 14 in Mpumalanga, 138 in Limpopo, 17 in Gauteng, and 7 in the Northern Cape. You will also notice, honorable members, that if you look at the statistics, specifically if you look at Limpopo currently, the cases that were lodged in Limpopo is about 347. So if you take 138 versus that number, you can see that the majority of those cases will end up in court because the landowners have rejected the status of those labor tenants. There are others that are still in draft in provinces, which are not counted on the 178 that I've mentioned. Next slide. This is just the graphic representation of what I've presented before in the previous slide. Next slide. This is the slide that is important, as I've indicated, that there are 6 judges in court. 7 of them. There are 7, not 6. This is how the spread of the 199 has been allocated by the court, which are under case management of those judges in different provinces. They are allocated in terms of provinces. You will see the cases with Judge Ncube with a lot of caseload, which is in KZN. Chali in Limpopo with a caseload of 39, and Judge Mia in Limpopo as well with a caseload of 94, which makes up that 189 cases that have been referred to court. They are under case management. All of these cases being handled by the courts. Next slide. This is just a graphic representation of this the cases that were filed in courts versus the cases that are currently under case management, and those that are not allocated, as I've indicated in the previous slide. 103 are yet to be allocated to judges in court.
We are in a meeting already, so the meeting will finish.
Can somebody mute to allow the presentation to go on uninterrupted?
Thank you very much, Honorable Chair. As I've indicated, the other blue green, I'm colorblind, but that green bar indicates those that have not yet been allocated by the land court to the judges, which we were hoping that also the 103 will eventually be allocated to judges under case management. Next slide. This is we wanted to share this with the honorable members and honorable committee that, as I indicated, once we have referred the matters to court, in as much as we are gathering some information, additional information to strengthen the cases for labor tenants. However, the court will direct us in terms of their schedule. This is the schedule that we have been afforded to by the court in terms of dealing with certain matters that we have referred to court. You can see that it drags until the 17th of February 2027. But you realize that with the quantum of cases that we have referred, not all these cases will be dealt with until February 2027 under case management. This is the schedule that were given to us, so that on the side of the department where there are areas where we need to serve notices, we are on board. When we see it, we have served the landowners with the notices and any other additional information that will be required. That is the schedule that has been given by the court. And I think this is a demonstration that once the matter is referred to court, the 302 and the other that were referred long time ago, once they are in the purview of the court, we've got no control on their schedule in terms of their schedule to deal with these particular matters. I think there's something that will have to be dealt with outside the unit. Next slide. We then looked at the bottlenecks as I've indicated, which are administrative, legal, etc. On the administrative side and operational side, these are the key areas that are hindering progress. One, as we have indicated previous presentations, that there is severe capacity shortages, especially dedicated personnel on board levels, national and provincial, to deal with these complex cases of labor tenants that are outstanding. Just to mention a few, as you remember, we have the National Program Manager for Labor Tenants dedicated to deal with labor tenants at a national level, but she works alone, and it's on contract. The data and case management backlogs, the issue of the legacy cases, which we have got a lot of them since 2013, which we still have to audit from 2016 to 2023. However, the court said, let's hold on for now so that we can deal with what the court can handle for now with the capacity that is available there. And then we need to also expedite the issue of cleaning our data, what we call the data cleansing. I think Professor Lavin will talk to that. The disputed claimant status is one of the issues that led us to refer almost 90% of what is outstanding for adjudication in court, which will obviously drag the delay the settlement of these applications, because we rely heavily on the court to adjudicate on these matters and settle them. Legal representation, I think they have noted, I think the chairperson in his opening remarks noted the issues around budgetary constraints within legal aid South Africa, the protracted court battles, the landowners, they have organized themselves and they are taking the department head on to court to fight for these cases as they dispute them. They contest it. They even contest the definition of these labor tenants, and then that is driving the legal expenses up, because the state has to have enough resources, financial resources, to defend the labor tenant claimants in court. The state attorney bottlenecks, there are capacity issues there on cases, especially the historic cases that I've mentioned, which were delayed because of the issues of capacity also experienced in there. I'm not going to talk about OVG because it's one of the areas where even if the parties have agreed, there are contestations around the issue of the price, which we have to take those to court for a determination of the price in court for adjudication. Those matters are also referred to court, even if there is a settlement agreement, but the price will be a problem. We have to take that matter to court in terms of the act for a determination of the price of the compensation. Untraceable claimants, we agreed we had developed the loss claims strategy to deal with this. However, the biggest hurdle here is that some of them have passed on, and there is a change of ownership, the property descriptions and relocation without updated contact details from the side of the department. We're handling them as we come across such claimants or in our processing of the labor tenants. The overlapping land claims with the restitution and labor tenants, or land redistribution beneficiaries on the same land, which is one of the hurdles. You will find that the labor tenant claims were settled in terms of restitution, and we are dealing with that through the restitution. Legal, I have indicated the issue of landowners, the negotiations which end up in court, and non-compliance and the legal aid bottlenecks in terms of legal, financial, the issue of the budget. In terms of our allocation from National Treasury, there is no separate budget or ring-fenced budget for the labor tenants program. The budget is combined for both for ESTA or farm occupiers together with the settlement of labor tenants. There is no separation between the budget that we are allocated from National Treasury as for this particular program, and the expenses are going higher in terms of legal representation and mediation expenses when we deal with these matters due to protracted legal battles with the landowners who are disputing the status of these labor tenants. Next one. The measures being implemented to improve the evaluation of the program. It has been agreed, and I think Professor Lavin will deal with that. How far are we? What is the current position? But that is one of the key areas so that we learn the lessons on where to improve on our systems. The referral framework has been developed with the between the department and special master to speed up the referrals. And then the labor tenants claims resolution system. We have this system, we have this developed. However, currently we need, through the advice from ICT, we just need to improve on this. Hence, there was a business case that was developed because currently it's not operational. It cannot be used by the provinces. The issue of the war rooms and provincial scrums, I think the DG has touched on this. We have agreed they are going to be bi-monthly or monthly. These particular structures to look at the bottlenecks and assist to unlock any other project implementation blockages. Next, also, one of these measures is to deal with the issue of the backlog, the cases that were referred from 2013 to 2023, to deal with all of those so that we unlock them. They then enter the case management within the land court. The mediation committee has been established to deal with this through the directive from the court. Is led by DJP. We are serving on that committee, and also our decentralization of mediation services to provinces closer to the people. That project will be finalized by March 2027. There is a status on those, but we are still at SCM. Others they've finalized. We've got the panels in provinces. Legal representation, pre-litigation. The department is setting up that panel. Is pre-litigation because during litigation, legal aid provides, but there was a cry around the pre-litigation before the matter is in court under case management. Legal aid provides that legal representation, but there is a need for such representation before we go for litigation, which the department is working on. And the submission is en route, being processed by the department. The capacity on the geospatial mapping, the geospatial mapping of these projects, as I've indicated, but 250 have been referred of these new cases. There is an agreement. There was a meeting to decentralize these services to provincial surveyor general's offices, and they are working on a plan to deal with these requests that we have forwarded to them. However, there is a proposed intervention which the special master will talk to on the Geospatial Intelligence Center. Next slide. The funding allocation, as I've indicated, we're still struggling there on the funding allocation, especially on the issue of the structure and the budget to have enough support capacity to deal with this particular program. That is what the department is looking at through the realignment project of the department. And then the issue of legal aid, because they've absorbed a lot of labor tenancy cases and other cases of farm occupiers, including restitution cases that need to go to court with the limited capacity. But I think they will dwell much on that during their presentation, honorable members. The next slide. These are additional measures, as I've indicated. I'm not going to dwell much because I've touched some of them, but what is more important here are the last two, the last three. We have decided to embark on a localized awareness campaigns so that we engage the labor tenants more comprehensively, in those that have lodged applications which we are untraceable to come, and we are designing that program right now. And then we are prioritizing any other labor tenant claims that are on state land or plus farms that were disposed and transferred to the state. We have identified those properties which we are busy disposing to settle labor tenants and also address the issue of occupiers. And then we need the fast tracking of the court referrals that we have in draft, the 178 that I have indicated in the slides above. Next. Honorable members, these four are as a result of the directive from the court as test cases to test the referral framework that we have developed. What is more interesting, I think, is what the Honorable Chair has indicated, especially the matter that that affects the Wachenlechen farm, where it affects the Nkambule family. Those four are test cases where we are testing this framework adopted by the department and special master. So we've done the GNI reports, the automated questionnaire on this. However, if I may be specific to Nkambule, that matter is being was referred to legal aid, and legal aid assigned Mr. Advocate Zulu, who is handling that matter. However, there was a previous attorney that was there before. When we contacted him, he said he has got no appetite to come back and deal with this matter because we were previously advised that he will be coming back. He said, no, he's not coming back. So therefore, the matter is handled by Legal Aid Advocate Zulu. And then I think Legal Aid here today can provide the status, how far, because we're just waiting for him to finalize all the consultations with the family. And then, because the matter was already referred to court, but it was referred in terms of Section 33 to A. So it's just a matter of going back to court. And in the meantime, we have in the process of appointing a mediator next week through the state attorney to mediate between the family and Mr. Langenman, who is the landowner. He's a very notorious landowner. He fights with everybody. But their attorney have agreed to say they would love to have that mediator appointed by the land court rather than by the department. We've responded and said we will be using the state attorney. It's not the department, but the state attorney, which is independent. So we're just waiting for their response. However, the process of appointing the mediator through the state attorney is on course. By next week, we are hopeful that state attorney will give us the name of that mediator, while the legal aid is finalizing the consultation and taking the matter back to court for adjudication. The next slide. Thank you very much, Ngiyabonga, Chairperson.
Well, thank you, DG. Back to the DG, if there is anything else.
No, thank you very much, Honorable Chair and honorable members. I think on the one issue around capacity, we have agreed both myself, the Special Master Prof. 11, to prioritize that area. DDG Lupungela, who's responsible for corporate services, is working on a plan to capacitate both the Special Master as per the requirements and also the unit within the department that is dealing with this matter. So I wanted just to emphasize that that is a matter that is receiving attention and will be implemented within this quarter that we are in. So I thought it is important just to highlight that. But thank you, Chair. Thank you. Let me not get into the details. Thank you.
Well, thank you, DG. Honorable members, I would need your guidance here. I'm a Democrat. I know that guidance should come from the chair, but there is nothing that prevents me from seeking your guidance here. Now that given the fact that the presentation that has just been made by the department relates to a large extent to the issues that are most likely going to be raised by the Special Master and the Legal Aid South Africa. Would it not be ideal for us to listen to all the presentations and then engage afterwards? Or the members would like to engage, separately on each of the issues?
Chairperson, let me be the first to agree that we get all the presentations and then engage afterwards.
Thank
In the
you,
interest of
Honorable Isaac. Is there any other comment?
No,
Honorable
Chair.
Nana?
No, Chair, it's a sensible proposal for us to get a holistic view and also deal with the presentations in a concise manner. I think it's only fair to get the other two presentations, and we can engage the whole lot at one go. Thanks.
Thank you, honorable members. Can we then, on the basis of that, then invite the presentation by the Special Master of Labor Tenants, and then after that we will then get the legal aid presentation. Thank you. Professor Lavigne, you are on the floor.
Thank you very much. I'm just trying to line up the presentation here. So that's what I want to do. I'm not used to Zoom. I work on Teams, but let me see what happens. Okay, I'm trying to upload it now, but otherwise I did provide it in advance, so it should be possible for me to okay, I'm not sure if the Secretariat is going to be able to put it up for me if you can't see it, because I'm not used to doing it in Zoom. I usually do it in Teams, and it works, but it's not sharing, despite my efforts to share it. So, yeah.
Could Mr. Ben actually assist? Oh, there you are.
Oh, okay. No, thank you very much. I guess I'll just have to indicate when each slide can be changed. So we can go to the first slide, please. Okay, so this is just a brief refresh on the mandate of the Special Master. Through the Mwelase Constitutional Court judgment, indeed, this particular subprogram of the department is under the judicial supervision and oversight of the Land Court, and a Special Master was appointed in order to operationalize that independent oversight mechanism. So supervise, monitor, and oversee is the formal stated mandate of the Special Master, but indeed, really, it does mean that we have to jointly with the department facilitate the processing of claims and report on implementation. And then we also need to assess systemic performance across investigation, evidence, referral, in terms of court directives that were issued on the 23rd of April, 2026. And subsequent to that, we have another set of directives that I will refer to as well. And then it has become practice over the years that we provide Parliament with independent evidence-based analysis, latest progress reporting, and so on and so forth. So if we can go to the next slide, please. It's true, as the chairperson said when he opened the meeting, that we have almost 3 decades that have passed, and that 8,913 of 20,524 claims are still unresolved after almost 30 years. And I think the big challenge remains that the figures are unreliable. So we will see if we drill into the figures, even the figures that have been given today, you know, there are different numbers that keep coming up from the time we started. And I'll talk about the remedy for it. It has already been mentioned as well in Mr. Zulu's presentation. So the major caseload has been in KwaZulu-Natal and in Mpumalanga. Mr. Zulu did indicate that it's likely that claims were lost, and hence we developed a lost claim strategy. And one can confirm from work in the field that many of the projects that we have gone down to as a special master, we find that the numbers of labor tenants who assert that they submitted claims and the number on record often do not tally. They don't count the same in the same way. So there are systemic delays across the investigation, evidence, and referral, which we need to talk about, and I will talk about them. And it's true that the court is currently managing a huge number of cases through case management. It slows it down, I can assure you, it absolutely slows it down. And the slow uptake of the systems, which is now crucial to turning things around, is also a hindrance. I will be attending with some colleagues from the department a stakeholder relations meeting in Limpopo on Friday, and I will have to leave for the airport. Hopefully it'll be finished by 1:30 latest in order to get there, because I'm meeting with the provincial office, and the initial sense I get is that the new instrument in terms of the court referral framework has not been applied, and that will definitely require a lot of intensive care in order to get those referrals into shape. Because the more we pile pressure on the court, and they are dealing with basic matters that should be available in the referrals, the more we slow the process down. And I think the big issue is that the labor tenant claims resolution system, I have spoken about this in virtually every presentation I've made to Parliament. It was formally approved by the department in October 2024, but it's not yet in production. And I will give a history of that as well. Next slide, please. So if we look at what we did in the beginning from the Office of the Special Master, working with the department's IT, and of course that was agriculture and land reform and rural development combined at that stage. So the decision was taken to build an in-house system over a commercial platform, and the business case and user requirement specifications were approved in February to March 2021. There was an Mpumalanga pilot at the end of 2021 where over 4,000 entries were made into the system. And subsequently, we added a labor tenants portal, which is a self-service facility through ID verification and a one-time PIN. So obviously, we need to have the system working before this particular portal can become active. And this portal is really in line with Batu Pili principles in South Africa. And that is to show that the department is responsive, that labor tenants themselves can make inquiries via SMS, and get a report on exactly where their claim is at a particular point in time. The National User Manual was finalized in time for the EXCO meeting, which approves the national use of the labor tenant claim resolution system and the hosting of the portal. And the department has committed to system training and broader access, migrating only verified information. Next slide, please. So currently, this is where the claims sit. If we look, we can go through it quite quickly. The majority in KwaZulu-Natal, 11,446 lodged, 6,510 finalized, and 4,936 outstanding. In Mpumalanga, 8,286 lodged, 4,918 finalized, with 3,368 outstanding. Next is Gauteng, Limpopo, Free State. The figures are there. I think you have them. I don't want to read them all out. But just to say that it's surprising. Those numbers are very surprising when you look at Free State, when you look at Limpopo, and then when you look at the history of South Africa, when labor tenancy evolved right up until 94, and the fact that you can have in one section of the Transvaal thousands and thousands recognized, and in Limpopo and the Northwest, tiny numbers. So there are issues there. I think Mr. Zulu, and we have discussed this thing before in Parliament, even during previous parliaments, that, you know, it was a consortium of NGOs that were hired to do this. And it could even be a reflection of the fact that the NGOs with significant presence were based in what became the two provinces. But anyway, these are things that have happened, and that's the situation. We can go to the next slide, thanks. Okay, so basically, when we started, we did have low targets, and those built up. And at a certain point, the department began setting targets itself outside the implementation plan. And whatever mechanism was used to set them, we can see that there was a massive struggle to actually get near to the targets. And clearly, this is what we have to turn around. And there is now a directive from the court, as we'll see, that requires myself and the DG to convene with all the relevant officials to look into this issue of targets. And in fact, in that directive as well, AFRA, who is the other party in the Molase case, has also been asked to participate. Next slide, please. So the system is blocked in terms of the fact that we have fragmented execution. Actually, if we look at what was submitted to the last court hearing by the department, there was an indication that 44 matters were finalized in Q1 against a 215 annual target. So that actually means that it's ahead of target, because the original target was 37. Then on the geospatial, I see different numbers today from what we were told before. But the point is, we actually need to get these standard operating procedures that we've been developing over the years formally approved, and for the relevant branch to make available staff. So it's a matter we are dealing with the DG, but we need to also utilize the capacity within spatial planning and land use management, in my view, to get to the kind of numbers that are awaiting national geospatial information. I have made proposals already to the DG that, you know, we can try and use contract employees. There's many land surveyors who are unemployed graduates in South Africa, and we need to just pull out all the stops in order to get the people in place. But at the end of the day, they need to be given the blueprint about how to technically process the geospatial information into a court-ready product. There's also inconsistent legal representation. So, you know, the head of legal aid very tragically passed away. And We have acting people in place, but there are critical issues. For example, if we want to look at the Nkambule matter, there are sort of inconsistencies in what was presented with what I'm aware of, because I worked very closely with the lawyer that had been brought in as Judy Care. And I explicitly asked him a couple of months ago if he would be willing to re-enter as legal representative of legal aid. And this followed a meeting I had with the Newcastle office where they recommended that I write to them and they would transmit that letter to the national office. I have been in contact with the national office on this matter on several occasions. The lawyer is willing. Mr. Mtimunye is willing, but he obviously has to be re-employed if it's going to happen. If it's not going to happen, Advocate Zulu, at the time when we went out with him into the field, was dealing with this one case amongst 69 other cases. So it's very important that we come to Parliament or when we go to court, we talk the truth as it is. And the truth as it is that legal aid is certainly building its capacity, but it doesn't currently have sufficient numbers of skilled, trained, and experienced lawyers who are going to be able to take on these matters. And that's why Mr. Zulu has referred to the fact that together with the court, we're trying to look at arrangements with probono.org, which is an NGO, but even with the 5 big law firms. And this is a process that began in 2024. But this is the extent to which we have to go in order to fill the gap. So whatever the decision was of the state to move the existing capacity which the department was managing through the LRMF and replace it, not augment it, replace it with legal aid, for me, honorable members, chairperson, that is something you need to look at closely, because this organization will not be able to take the volumes. I can state that unequivocally at this point. It will just not be possible for them to take up the volumes. But it's inscribed within the law now. And that is where the constraint will be, because from a National Treasury perspective, they're going to want to know why, since all the money was put into this other organization, why is it that, there are now requests for additional funding? So I think the whole area is under-resourced. So legal defense of the people who are involved in criminal activity has now been combined with a social justice program, which is a new function within Legal Aid South Africa, and it's not easy for them to meet this demand. I can say that straight up. And even as it strengthens, it's still way behind in terms of required capacity to deal with the volumes that we're talking about, especially if we listen to those numbers that Mr. Zulu has presented to the Honorable Committee, that I want to know how the court is firstly going to cope with case managing, because I think we all understand that case managing is not like going to a hearing, but the court is going to be giving the parties instructions. They're going to have to go away and fulfill them, and so on and so forth. We also obviously need to maybe talk more about mediation than we are in order to make mediation more effective, because it will be faster if mediation is effective. On our side, the DG has indicated that there is going to be support, but I think it's important to say that at the moment, the way we're functioning is not very helpful to this program. We've had specialist professional positions that were agreed on in 2020, and it's only now that deviation is being sought from the Minister of Public Service to employ these people. And if it is not sped up, we're going to be in a situation where we get into the new year, we're not going to be able to attract proper candidates, because under the current arrangements, I'm working on 5-year contracts. So there'll be 3 years left, and people may not want to come into a contract position as opposed to a sustainable position. So the referral framework has not been operationalized. Mr. Zulu spoke about our agreement on, and we've reported to court that before. It's absolutely seminal, that particular agreement. But that means that we have all these draft referrals piling up. And despite the impressive figures in terms of Limpopo, and I'm meeting with them tomorrow, it doesn't appear that any of what they are putting together is done in terms of the court referral framework. And that's just going to lead to more delays. So we need to really get the facts on the table in the next 2 days and come with an intervention to see how we are going to align the referrals with the referral framework, if that is not the case at the moment from Limpopo. The war room, you see, I'm glad that the DG has made such a commitment and that we're going to have a monthly war room meeting and provincial engagement or scrums twice every month. That's critical, but the fact of the matter is the last meeting took place in October of 2025. So there's just been this hiatus of talking about a war room, and you've heard it, honorable members, without any war room being implemented. Next slide, please. So the system, the labor tenant claims resolution system, if you study word by word what happened in the court from 2013 to 2019, the department could never accurately respond to how many claims per province, per district, and even the numbers now, they bounce around all the time. So this data system, in terms of administrative duties of the DG of this department, is absolutely fundamental that we get this one right. If we are going to claim that we complete it in the next 8 to 10 years, we must be able to close it out properly for the archives of this country to know these were the recorded applicants, this is how the matters were resolved, etc., etc. So the data cleansing is not commenced. Obviously, you need to clean before you can migrate the data. Then in terms of all the documentation, there has to be user-accepted testing on verified data. That is outstanding. And then a change advisory board, which is the structure of the system, which is not in place at all. So all that documentation I have provided to the DG, and we're going to have to sit and really make this thing come to life now. There are institutional causes as opposed to technical, because that's the first debate that we need to settle. Is there a problem with the system? If there is, we must fix it. If there's not, then we got to get the institutions lined up. We know that the machinery of government split, separating agriculture from land reform, created another delay, because we had started to do a provincial rollout, but because of cost containment, we weren't allowed to travel anymore. We had to stop. And this is now, you know, we're talking like 2 years ago already that these things will happen. And then in Mpumalanga, where there was considerable data entry into the system, the temporary contracts lapsed, and then we had to wait for the people to be re-employed, and that dispersed the most system literate staff that had been created at the time. And then there's a continuity risk, because in the previously merged department, the 4 developers who built and maintained the system left the department. So now we have to work with the capacity within what is now land reform and rural development. Next slide, please. So the court has now directed a strategic reset compact, and I've already made a draft of it and I've shared it with the DG, and we will have to get together with our teams because we are supposed to put this compact on the table by the end of August. Essentially what this compact is doing is saying that in order for this program to accelerate, there are 3 pillars that we need. The first is the labor tenant claims resolution system. The second is the enhanced land rights inquiry. because when we talk about problems with definition, like Mr. Zulu said, if we implement the enhanced land rights inquiry, we're not going to have that problem because all the evidentiary proof will be there, both in terms of the oral history as well as the geospatial analysis, which will give the court the opportunity then and the lawyers, without doing an additional work other than meeting their clients, as they call citizens who are labor tenants in this country, and then verifying the information coming from the department is when they write the founding affidavit and do the other legal work that they have to. So that is the one, the two pillars, and the third is the court referral framework, which shows exactly how a referral should be laid out with all the evidential requirements coming and going through legal aid to draft the founding affidavit, and then being court ready so that by the time the statement, it gives enough time to draft the statement of claim within the required turnaround period from the land court. So there's the monthly war room, the bi-monthly scrums, there's the legal representation committee, there's the department report on legal representation. Well, this is something that we have to do, and there's already been an indication from the DG that we do need to engage with the DG of Justice. We do need to engage with legal aid, and we do, in my view, the DG as the accounting officer needs to engage with the National Treasury to see if there is not going to be a way in which special legal representation can be brought in to assist. Because as much as we can go for pro bono lawyers, whether in the NGO sector or the private sector, that was never the intention that I read when I started this job, is that I would be fully capacitated to supervise, monitor, and oversee all the work that is required to accelerate the claims. And that is why our initial targets were so high, because I thought all those requirements would be in place. So this requires, you know, the three branches of the state to get together and make sure that we are going to have adequate numbers of skilled, trained, and qualified lawyers. Okay, the other party to the Mwelase, AFRA, has made requests to the department, and there's already an indication that the department will be able to report on that. We just need to cooperate around that to make sure that that becomes a standard section within the report of the special master. So originally there was talk about separate reports, but before this parliament, and indeed before the court when the time comes, I would assert that the more we collaborate and cooperate, the better the result is going to be. We are not there to compete against each other. We are there to collaborate. Special Master, DG and department, Special Master and Special Master's office staff, and the department and their staff. It is a collaborative arrangement, not a competitive one. So ultimately, even when we come and report to Parliament, we should probably align ourselves better than we have today. We have to meet on new targets. I've already indicated that. Staffing of the SMLT office, and then the historical cases compliance. You see, that one also required a different kind of explanation, although it was there in the text. At a certain point in time, there is a provision within the Labour Tenant Act, Section 33(2)A, which allows direct access to the court from labour tenants. And at a certain point in time, the Land Rights Management Facility did encourage lawyers who they had contracted to try Section 33(2)A. But then there was a landmark judgment by Judge Ngube on a Mhlongo matter. And basically, the judgment was that through direct access, you can only get declaration of labour tenant status. You cannot get an award of land. So those matters that are in the historical cases project, you know, we're going to have to basically, firstly, like Mr. Zulu said, see which ones have Section 16 applications and which ones don't. The possibility of a lost claim would have to be explored in those cases where there is no Section 16. But then, you know, those files probably, they may have to be reopened, or they may have to amend the existing papers, or whatever is done. All of those will create further delays in the court process. But certainly, I would say that the first thing that needs to happen is that the department must not try and fix its case files that it has on all these matters. It must submit them. You know, that the Deputy Judge President spoke to me again yesterday and asked me to seriously impress upon the department the importance of submitting everything they have, so that we can then audit and verify the information that's there, begin to you know, fill in the gaps, but not to try and fix it before it comes, because it's creating a delay already while we're still trying to start. Next slide, please. Now, in the strategic reset, we're talking about disciplined implementation. This doesn't mean we're starting anything freshly. We're basically saying this is where we are, and this is what we must start doing. We must implement the Labour Tenant Claims Resolution data system. We must implement the enhanced land rights inquiry. We must implement the court referral framework. And those will be the three pillars that can turn this thing around. If we just focus on that single focus, war room, provincial scrums twice a month. Obviously, I have more time than the DG, but as long as we aligned and it's clear from the level of the DG, I will be able to drive these things. Even with the small staff complement I have, I'll be able to drive these. But we also need to talk about the way in which we work together with the department. Like I say, as instead of us and them, they will do this, they'll come and say this in Parliament, I'll come and say something else into Parliament. This kind of alignment is absolutely fundamental. Going beyond the separation of powers in the situation I presently find myself, to focusing on what is required to make the Labour Tenant Act work, to activate all the available capacity as it is now, and to get the whole process to move much more decisively. So the leadership that has been displayed by the DG up until now, since he came in, it's barely a month, yes, that's true, is really giving me hope that we are going to turn things around. And through these things I'm talking about, we're going to draft a delivery compact so that it's clear roles and responsibilities, etc. All of that is clearly laid out. And this partnership that we've been talking about between the special master and the department becomes a partnership of fact, not a partnership of saying, well, we have a partnership with the department, or we have a partnership with the special master, but it doesn't really exist in practice. Then obviously, geospatial intelligence is fundamental. There was a lot of pushback when I came with that as a key new feature of the delivery process, but the court rules always have required a description of the land which is under dispute or under claim. And since a lot of it does not coincide neatly with existing portions, this issue of measurement is fundamental. Measurement doesn't mean the Labour tenant will get everything because of case law. Case law needs to be changed. And that is why for 2 years now, I've been requesting we have a strategic litigation workshop. And the honourable members will remember that even more than a year ago, we came and the acting DG confirmed that the minister would be opening that workshop, and the minister's still waiting to open that workshop, and we need to get it together. So can we please get the concept document back from the department so that we can kick this one into action? Now, all these things that I'm talking about will restore accountability and workflow discipline. So accountability for this whole program actually lies with the DG and myself. So it's going to be up to the two of us to ensure that there's a clear pathway for all those involved in this effort to work in a disciplined way, using the tools and instruments that we've developed in order to get the results that we want to project here. Next slide, please. And this is what I was asked last time. So I'm giving the answer now based on initial discussions I've had with the DG that we should move to an 8 to 10 year arc as opposed to the kind of arc we would get if we look at the current targets, which would be 35 to 40 years. And this is how the buildup has to take place. Now, these are obviously just numbers, but you can see we're talking what's doable, because we're saying, right, as we move into this reset and we make sure that the systems become operational and functional, we are going to focus on the existing target. The special master needs to know the details of the target, not just that it's 250 cases. And that's really what AFRA's asking for in the reports, is lay out what's on the project register for this year. And then we can put in the test cases, the MACRE, the so-called MACRE, and the proof of concept and all of that, and even the historical cases backlog. And then we can come with accurate numbers about what we intend to do in phase one. But basically, one is taking the existing target as we reorganize the back office in a decisive way, or to move forward decisively. And then you can see the build-up of the cases over a kind of 8 to 10 year period, where we would have to reach a peak of up to 2,000 cases a year in the final 3 years or so. So these are indicative, these targets. The achievability assumes full deployment of the standard operating procedures, which is the enhanced land rights inquiry in particular, because many of the standard operating procedures have not necessarily been substantially reviewed. It's only the land rights inquiry that was found in my role to be deficient. And that is fixed because now we have an approach. The project tracking tool gating. So the project tracking tool is linked to the claims resolution system, so that when we go to war rooms, we actually see on an Excel spreadsheet exactly the progress made in each project. That's where we identify the blockage, and that's where we unblock the blockage. So the war room was never meant for me to be a thing where we all go and discuss strategy and this and that. It's really an operational war room. And that's what I've been asking for years. And now we have agreement from the DG and consensus exactly how it's going to happen. And if it happens like that, we will start seeing a change in these results. And then there's the issue of automation. So currently, we don't really have automation. We have revised instruments, but there has been an initiative with the branch of spatial planning and land use management, where we've captured the founding questionnaire onto a device. It can be captured in a device. So they have an application that can be captured on a device, ArcGIS Survey 123. So you can actually administer with a smart device in the field the questionnaire. You can also capture points, key points, which then can be used for the geospatial analysis right there in the field. It can be done with a surveyor, or it can be done with a geographical information systems expert, which you have in spatial planning and land use management. And the level of detail required at that stage in the court process is not necessarily the same level of detail you would require to affect a subdivision of land. But it would be enough for the court to make an order and a determination on how a matter should be resolved in terms of the extent of land. So once these things have been captured in the field, you get an audio tape as well as the copy of the questionnaire where you've typed in things on the smart device to a central server. That will transcribe and translate the interview. A referral template has been created, and then it will be populated automatically to produce a draft court referral compliant with the agreed framework, with all data held in a geographical information system. And then every draft is manually quality assured before release, because obviously automation cannot substitute for that review. So this is the future that we can imagine and we can do as long as we are focused, as long as we take things, do things, everything properly in terms of documentation to make sure that these now are the standards that every single official dealing with these matter from the project officer upwards understand the whole system. It can be tracked, progress can then be tracked, and we will be able to turn it around if we are going to do this in the way I'm suggesting. Yes, next slide, please. So just to amplify on the issue about the instruments without over roasting the walnut, if I can put it that way. So like we've said, 329 matters sent to NGI. I saw 250 from Mr. Zulu's presentation. Whatever it is, we're talking about draft referrals that have been stalled. We talk about numbers that were referred via the National Program Manager and the numbers under case management. So we have to align everything that I've spoken about, apply the court referral framework, and suddenly we're looking at a pipeline going into court, which is much bigger than it currently is. And what is now is going into case management as opposed to actual adjudication if mediation has failed, because mediation is increasingly going to become a compulsory step. That is the future of all civil litigated matters through the high courts, of which the land court is an equivalent across the length and breadth of the country. So there's been a delay in the proof of concept test cases. There is information that's missing, but like Mr. Zulu has asserted, we are definitely moving forward now. We've identified the case, and Kambules is one of them. And the first step for us is to hear from legal aid whether there is any hope of re-employing the Judicare. I was told that the criteria used, this matter fits the criteria because the Judicare was in the process of negotiating a pretrial conference at the point where he was I don't know if I said dismissed is the right word, but his mandate was terminated. Terminated is the right word. Yeah. Then the historical cases project, pending departmental case files. Again, the appeal is if we can get those, whatever is available. What's not available, we'll engage with the department. We'll fill the gaps so that we can begin to get everything that's in the historical cases backlog court ready. Obviously, the SMLT back office. So the challenges, are getting enough people, because even we have 2 now, but even if we have 3, it's not going to really be adequate. And we had far more in the past. That is a fact. And they never allowed to travel with me, even when I needed administrative support, which is something I can't understand either. But that is, I will discuss with the DG. Yes, we exceeded the first quarter target, but that's without systemic support. So we've got a lot of activity going on, but we don't have delivery. And this is really what the Special Master has been emphasizing for the past years and what must happen now. We're not interested in process. We're interested in outputs, in impact and outcome. And that's what we must focus on. Next slide, please. So just to basically indicate here, we want to turn evidence into referrals. So we must have the national geospatial standard setting. We must automate because that will speed up. We must have, quality assurance. And we have to then look at how the department will solve certain matters. So I've heard Mr. Zulu on several occasions saying that on state land, they want to dispose the land in favor of labor tenants. I think we all need to know more about that process, because what I know is that in many of these areas where you have state land and you've got labor tenants and farm dwellers, there's a lot of unhappiness about what has happened there, obviously accompanied by a plus land redistribution project, where the relations between the labor tenants and the farm dwellers who remain on that land and the new land leasee are not that good either. So I think those issues are fine. If we're going to use the state land disposal mechanism to increase the numbers, but then the principles that the department applies in allocating land. So I've just quoted one example, which is on our books, and we've been discussing with the department. There's a gap between what is being offered and what has been claimed. Now, in a court of law, it's unusual in terms of case law for labor tenants to get an award of more than half the land. Of course, a precedent needs to be created at the right time. But still, the point is when state land is disposed in favor of labor tenants and farm dwellers for that matter. I may not have any mandate over farm dwellers, but I'm just as concerned about their conditions of existence, having worked extensively on actual farms. So really, all of what I'm talking about is we need to convert evidence into referral-ready outputs. Next slide, please. So if we look at the representation gap again, just to reiterate the points I've made, we have a representation gap across the 8,900, because again, the number was higher today than it's been in earlier reports from the department. And this is why we just got to get this, accredited system in place, which is going to be the truth. Otherwise, we continue with untruth wherever we go, DG. And aid capacity constraints, obviously dealing with the gap in legal aid following the sad passing of Mr. Mbenze. And then the whole issue of paralegals in this process of the historical cases project, which we want to be testing now. We've been talking about it since 24. I tried to make an intervention last year, but was prevented from doing so in terms of kickstarting it even earlier than it is being kickstarted now. But I think, really we got to get this whole system to work. So paralegals are going to be part of the process to work with pro bono lawyers to fill the gaps in the files where they exist in order to be able to move this thing. Now, obviously, the precise role played by the department, given the capacity deficit which it has, is going to be critical. And we haven't really discussed that properly. But in my view, the department needs to be properly involved, and the court certainly wants it that way. But then the numbers of project officers is not sufficient to really move to the kind of level of implementation that we're looking at. And then we have a 5-member committee that's been set up, and pro bono and AFRA need to be integrated into this whole issue of legal representation. Currently, they are integrated into the mediation committee, but into the legal representation committee. That's just a recent court directive from the 4th of August hearing. Then training and disbursements are required. In order for the pro bono lawyers in the NGO structure probono.org to be activated, they need money for disbursements. There's a possibility that if the private law firms come to the party, as originally was the intention when we met in their offices in December of 2024, then there may be a way of getting around this issue of disbursements. So people will work for free, but we can't expect them to cover their own subsistence and travel costs, printing costs, whatever they have to do in order to put documentations together and so on. They will need disbursement money to cover their costs. And obviously, whatever we come up with in this area is going to be critical to unlocking historical and new cases. But in terms of the land question in this country and all its various dimensions, there's public law capacity needs to be created. And wherever it takes place, whether it's split between legal aid and the Department of Land Reform and Rural Development, those are bigger questions and discussions that have to happen in order for money to come into the play. But certainly the honorable members will have a big say in that. Next slide, please. So, okay, we as Mr. Zulu's pointed out, we've got about 70 dormant cases. We flagging 20 priority matters, or even slightly just less, to just kickstart the process. And then the matters which have been referred to the land court by the National Program Manager, which are under case management. And there's different numbers we've seen on all of that. And certainly we need to get our numbers lined up properly going forward around that. And then we need to look at missing records, missing departmental files, missing claimant contact details. There's another program that we were dealing with, or project really, where the minister had handed out title deeds, and then I just made a casual request. I thought it was, okay, can we just get the names of the people so that we could compare them against the existing spreadsheet records? And this has taken, it's going for 2 years now. And on that process, we still have, we have 947 names instead of the 1,000 names we said should be there. So basically, the reset is going to unblock all of this if it works as it should, and the case management workflow as a whole. Next slide, please. So the 9 steps that we can talk about based on what I'm saying, we must operationalize the GIIC is the Geospatial Investigation Intelligence Center, because the proposal is that within the NGMS branch, National Geomatic Management Services branch, we will have, or we do have, the National Geospatial Institute. And since we worked from them, because the original national program manager, Mr. Tamiam Donswa, took me there when I said this is how I think we need to investigate the extent of land that labor tenants are claiming. And we began the arrangements there and the relationship with this institute within the NGMS branch. And we made this proposal, it's probably almost 2 years ago, about the GIIC, or maybe it's over a year, not close to 2 years yet. So all of that must be done. The war room activation, strengthened legal representation, the alignment in provincial execution. In other words, the provinces need to know about all these systems I'm talking to the honourable members about, because right now they don't know about them, or they know about them unevenly. So they know about them more in Mpumalanga, but then the staffing situation is less adequate. The restoration of SMLT staffing, the complete provincial data cleansing and secure governance committee for the labor tenant claims resolution system to go live, quarterly accountability to the court, and obviously with Parliament, however often Parliament calls the department and the special master. And then an integration of the paralegals from the Department of Justice and the strengthened mediation capacity. Next slide, please. So, honorable members, chairperson, DG, this is a moment of opportunity. With disciplined implementation, the aligned and fresh DG leadership, which I've experienced, and strengthened oversight, we can finally deliver on the constitutional promise of the Labour Tenants Act. I thank you very much for the opportunity.
Well, thank you very much, Professor Lavin. It was such a comprehensive presentation. I'm sure members are itching to engage, but I would rather ask them to please hold your horses and allow Legal Aid South Africa to actually continue to whet your appetite. Over to the Legal Aid South Africa.
Thank you, Chairperson, Honorable Chair, and good morning, honorable members, and also colleagues from the department and also from the Special Master. My name is Mantiti Kula, the CEO of Legal Aid SA, and joining me today, I have the Chief Operations Officer, Mr. Nsumbizeni Nemasisi. Mr. Nemasisi is responsible for the overall legal service delivery, criminal, civil, strategic, litigation, land, and the advice line. I also have in attendance the Chief Corporate Services Executive, Mr. Sitopo Mamuteti, who's responsible for the overall support operations within legal aid, and also the Chief Financial Officer, Mayor Precious Bingo. And I also have in attendance our National Senior Legal Manager for Civil and our National Senior Manager for Land Rights Management. The two senior legal managers have been assisting the COO following the demise of our beloved Mr. Mbenze. In terms of our presentation outline, we wanted to, with your permission, Chairperson, to just take a moment to pay tribute to our late colleague, Mr. Thabiso Mbenze. Chair,
Yes,
may I request the presentation be in the presentation mode? Mr. Nemasisi. So the presentation outline will capture our remembrance of Mr. Thabiso Mbenze, our former legal executive, national responsible for land rights management and civil offering. And we'll also have included presentation on the Legal Aid SA overview, the labor tenants' rights, the court-ready labor tenants cases, the primary bottlenecks affecting the finalization of the labor tenant claims, funding and resources, and also measures to accelerate the processing and finalization of labor tenants claims. And also we included measures to strengthening access to justice for labor tenants. The Board of Legal Aid, the executive management present here, and the entire staff of Legal Aid SA mourn the loss of a greatly valued colleague, leader, and a friend, Mr. Thabiso Mbenze, who sadly passed away on the 22nd of June 2026. Mr. Mbenze joined Legal Aid SA on the 1st of August 2021 as a legal executive dedicated for the land rights management. He immediately became an integral part of our entity. He was instrumental in establishing and leading the land rights management unit from January 2022. And for the past 3.5 years, he dedicated his services to establishing this unit that, as we speak today, boasts of a strong 46-member legal practitioners. His vision, expertise, and determination ensured that the vulnerable communities received quality legal representation in complex and land right matters. Mr. Mbenze, as he was affectionately known as Indoda Yomhlaba, appeared before this honorable committee on several occasions. His contribution to our entity, the legal profession, and the broader South African society, especially the labor tenants, will forever be remembered with gratitude, admiration, and profound respect. His expertise and commitment to the advancement of justice contributed significantly to several landmark matters, including the Moelase versus the Department of Rural Development and Land Reform, and Caesar versus Director General of the Department, Rural Development and Land Reform that the colleagues have alluded to in their presentation. May his precious soul rest in eternal peace. With your permission.
On that note, honorable members, may I request that we observe a minute of silence in remembrance of our beloved colleague, Mr. Mpense. Yeah. May his soul rest in eternal peace. Thank you.
Thank you, Honorable Chairperson, and thank you to the committee as well for honoring our Tabiso. With your permission, Chair, I'm going to ask the Chief Operations Officer, Mr. Nemasisi, to proceed with our submission before this committee. Over to you, Mr. Nemasisi.
Thank you so much, CEO. Good morning, Honorable Chair and Honorable members, the DG of the department, the Special Master, as well as colleagues from Legal Aid. Honorable Chair, I'm struggling with sharing the screen. I think same as the Special Master, I'm not used to Zoom. I normally use Teams, so I wanted to check if the Secretariat can assist with sharing the presentation.
Mr. Ben, are you able to assist?
Yes, Chair, I'm just trying to load it, Chair.
Apologies, Chair, for that delay.
Chairperson, with your permission, Mr. Nemasisi, you may proceed with the background while they're trying to load the presentation.
Thanks. Thank you so much, Chair. Chair, I'm going to start at slide number 11, where we're providing the labor tenants' rights background. Chair, our presentation will start with the provision of the constitutions, where you find this from section 25(6) of the Constitution, which provide that a person or community whose tenure of land is legally insecure as a result of past racial discrimination law or practices is entitled to the extent provided by an act of parliament, either to tenure which is legally secure or to comparable redress. Section 25(9) of the Constitution also makes it clear that Parliament must enact the envisaged legislation. In fulfillment of that obligation, Parliament has passed several pieces of legislation to give effect to these constitutional rights. And one of these is the Land Reform, which is the Labor Tenant Act, number 3 of 1996. Slide 13. Section 3 of the Land Tenant Act provide that a person who was a labor tenant on 2nd June 1995 shall have the right with his or her family members to occupy or use that part of the farm in question. And then if you look at section 16 of the LTA Chair, which provide for the acquisition of ownership or other rights in land by labor tenants, that section allowed for labor tenants to apply to the Director General to award the land which he or she is entitled to occupy or use in terms of section 3. It protects them from unlawful eviction, allows them to apply to the DG of Land Reform and Rural Development for the rights over the land that they occupy, including ownership. A number of thousands of labor tenants took up that invitation and made application for the rights in their land before the cut-off date of 31st March 2001. Honorable Chair and members, it is impossible to state the exact number of applications lodged before the cutoff date of 2001, but we are informed that from different handover documents that an estimated 20,000 applications for land for rights in land were lodged by labor tenants before the cutoff date of 31st March 2001. Unfortunately, Chair, not all applications have been processed, and therefore the rights envisaged in Section 25(6) of the Constitution are not being sufficiently protected. And things the department as well as the special master did indicate about the challenges with regard to some of the referrals that may be lost. Chair, Honorable Chair, if there is a dispute about whether or not the person is a labor tenant, the matter must be referred to an arbitrator or the labor court. If the court determines that the applicant who applied for acquisition of land is a labor tenant, it must then determine the award to make to the applicant. That can include the award of ownership of the land or substitute to either the land tenant or the owner, or compensation to the labor tenant instead of an award of the rest in land. The Labor Tenant Act targets labor tenants, and the majority of them are the most vulnerable people in our country. Honorable Chair, if I move to the slide 16, this is where we deal with the court-ready labor tenants cases. In January 2022, Legal Aid took over the mandate to provide legal representation in land matters. This includes labor tenant matters from the Department of Agriculture, Land Reform and Rural Development, which is now called the Department of Land Reform and Rural Development. Legal Aid SA inherited about 205 matters involving the interpretation of the Labor Tenant Act from the department. And these matters were at various litigation stages when we inherited, and some matters were not referred to court yet for adjudication. Of the total 205 inherited labor tenant matters, 115, which is about 56%, have now been finalized to date. If we go to the next slide, slide 17, we show in the table, Chair, where that we also have, since we've taken over the mandate, we have received about 443 new labor tenants matters. And of the total of those matters that we have received, about 245, this represents about 55% of those matters, new matters, labor tenants that we have received have now been finalized. Since taking over the land mandate, Legal Aid handled about 647 labor tenant matters. And this is the 204 that we have inherited, as well as the 443. And the total number that we have now finalized, which is about 360, and this represents about 56% of the matters that we have now finalized since taking over the mandate in terms of labor tenants matters. The total pending labor tenants matters stand at 287 as of 31st July 2026. The next few slides, Honorable Chair and members, present the high-level statistics of the performance of Legal Aid in terms of labor tenants matters. Slide 18. If you look at this table, Chair, it will show that majority of new matters taken by Legal Aid are actually in KZN, wherein about 326 matters are actually received in KZN. Limpopo and Mpumalanga is the second one with about 73. We had high number of labor tenants in 2024-25, where about 100 new matters were received, and 25-26, about 118. To date, we have received about 30 labor tenants matter, and this financial year only, it's about 30. Obviously, we are expecting more referral matters, labor tenant matters. We now move to slide 19, which we now break down the pending matters in terms of the province. Our pending workload reflects a similar trend that KZN and Mpumalanga provinces carries the highest number of labor tenants matters, being 206 in KZN and 48 in Mpumalanga. Out of 287 labor tenants matters pending, 283 matters, Honorable Chair and members, are handled internally, meaning by our legal practitioners, and only 4 labor tenants matters are handled by the private legal practitioner, which we normally call them judicare. And this is because, Chair, as I indicated later slide, that we have started to build in internal capacity as legal aid for us to be able to handle those matters internally. If we were to go to slide 20, where we then look at the finalized labor tenants matters, out of 360 matters finalized since taking over the mandate, 78 of those matters were taken to court and finalized as follows. 5 matters were unsuccessful after the trial, 17 matters were successful after the trial, and 56 were resolved successfully through alternative dispute resolution. This shows, Honorable Chair and members, that alternative dispute resolution should be the preferred measure in order to fast-track the finalization of those labor tenants matters. The remaining matters, Honorable Chair and members, were finalized through various means, which include withdrawal due to lack of prospect of success. In other matters, Honorable Chair and members, clients have passed away and there is no successors that we could find. And as a result, we were forced to then withdraw those matters. And others, it's a few of those where our mandate would have been terminated, where the claimants would have resolved to appoint their own private law firms. And others is when the clients choose to appoint their private law firms. So if we move to slide 21, where we then make reference to the number of labor tenants which are court ready. In total, Chair, as we indicated, about out of 287 labor tenants matter currently pending, only 139 matters are currently enrolled at court, and 148 matters are not ready and are awaiting the Section 16 referral from the department. Of these 139 matters that are currently enrolled in court, about 66, I'm just correcting the numbers in the slide that we presented, Chair, about 66 matters are enrolled in terms of Section 33, 2A, capital A, in order to protect the client's rights as labor tenants. And this, obviously, we use Section 33, 2A, pending the resolution of Section 16 labor tenancy claims as well. And the total of 73 matters are enrolled in terms of Section 16, in terms of which the department would have made the referral in court. If you go to slide 22, the 73 labor tenants matters enrolled at court under Section 16 are at various stages in the litigation process. One is the parties are in the process of filing notice to participate. The second stage will be drafting statement of claims that needs to be filed. The other stage is the awaiting response from the landowner to file their statements of defense, to respond to our statement of claim. The other stages are awaiting expert reports, such as land surveyors as well as valuers, and I think the special master did touch on those. And other stages is when matters are under settlement negotiations, which has proven to be most appropriate and quickest way to finalize labor tenants claims. If we go to slide 23, the remaining 148 labor tenants matter, those matters in which we are waiting for the department to refer the matter to court in terms of Section 16. In these matters, Honorable Chair and members, clients would have come to our offices and instruct us that they have lodged their claims with the department and nothing is happening with their claims. So we are currently, Chair, engaging the department to process those claims in accordance with Section 16 so that we can then have those labor tenants claims adjudicated in court. So in total, Honorable Chair, about 208 labor tenants matters have not been referred to court in terms of Section 16, and those are the ones that we are aware of. And this includes the 66 matters which are currently litigating under Section 33, 2, capital A. Accordingly, Chair and Honorable Chair and members, only 73 labor tenants matters are enrolled at court under Section 16 of Labor Tenant Act. So we have attached, Honorable Chair and members, the spreadsheet which contains the current status of each labor tenant matter, and this will we have submitted as part of the bundle that's before this committee. Honorable Chair, we have been asked to make presentation with regard to the principal bottlenecks affecting the finalization of the labor tenants. Most of the bottlenecks that have been referred to by the department as well as the special master. But to add on those one, Chair, we then categorize them as those that are procedural bottlenecks. And the first one was saying referral of labor tenants claims in terms of Section 16 to Land Court are still delays, and the department has indicated that there are measures in place that they are putting in place to ensure that those matters are referred to court. So the department is committed. They've indicated that they are putting measures in place to address those ones. Chair, at some point around July 2025, we did send a letter to the department where we indicated that we've got 14 clients who came to us who indicated that there are Section 16 are not being referred. The department responded to that letter and they then gazetted about 7 of those claims. Chair, this type of approach where we send a letter to demand the department to refer some of the matters, it's rather, Chair, it should be a last resort, and legal aids rather like to find a more collegial solution with the department, as both parties have same goal, which is to achieve land rights reform. And I think the special master did touch on that we should work together and not compete against each other because we've got the same goal. The other procedural bottlenecks that we are identifying over and above those indicated by the department as well as the special master is the referral in terms of Section 18, which does not provide for the labor tenants to initiate any type of mediation. This means that we need to wait for the landowner to respond to the department. So we are suggesting, Honorable Chair and members, that the department or the parliament may consider some type of regulations that allow for any party to initiate mediation process prior to litigation in terms of Section 18 and not only give that rights to the landowner. Honorable Chair and members, we are part of the mediation guideline task team, which has been considered by the JP, and this proposal has been tabled there. Hopefully, there will be some movement in terms of amendment of Section 18 to give that rights of initiating to both parties, not only the landowners, that because mediation has proven to be the most appropriate way to speedily resolve those matters. Over and above being a member of the mediation guideline task team, Legal Aid SA has a standing quarterly meetings nationally with the department, and as well as we do meet from time to time with the special master as well. In terms of administrative bottlenecks that we have identified, Honorable Chair, in slide 26 is the geospatial report, which the special master referred to it. These reports are very important, Honorable Chair and members, because they support a claim of labor tenants in terms of the location of the land and the extent of the land in which there is a claim. The delays in acquiring these reports cause unnecessary delays in the finalization of the matters. Another administrative bottleneck is the claim supporting documents. Honorable Chair and members, we have identified that some of the referrals to court only contains the claims lodged by the claimants and no further supporting documents or contact details of the claimants. This results in our legal practitioner having to engage the department with this outstanding document or contact information, which further delays the finalization of the matters as well. And I think the department did touch on that in their presentation, that there are instances wherein we do not have the contact details of those claimants that we have. The Honorable Chair and members, who have also requested to make a presentation on the funding and resources that are required by legal aid. That's slide 28, slide 29. Honorable Chair, legal aid in this financial year 26-27 has suffered substantial budget cut, about 261 million of our budget for only this financial year 26-27 has been cut off. So with the budget cut of 261, we have cut down on the allocating work to the judicare practitioner. The special master referred on several occasions that there are judicare practitioners that has been withdrawn instruction from them because we handle that internally. And we want to place this on record, Honorable Chair, that an amount of about 269 million has been cut off from our budget. As a public institution, Honorable Chair, we have to then put measures in place to ensure that we only spend what we have in our pockets. So we could not continue to allocate matters to outsource it to the service provider when we do not have money to pay for those services. And that would be against the PFMA. And as a result, a decision was then taken to ensure that we have to cut down on allocating outsourcing work to the Judicare and work only with our internal capacity. As a result, Chair, 283 pending matters are being attended to by our internal legal practitioners, and only in terms of this is only in terms of the labor tenant matters. Only 4 matters, which is about 1.4% of pending matters, are handled by private practitioner. So that's the reason why we had to take that measures, and it's what the National Treasury has directed to all public entities who are faced with these budget challenges, that we must put measures in place to do our work within our budget. We cannot go and do outsource work and incur expenditure that we may not be able to pay for those services. Honorable Chair and members, presently Legal Aid SA has capacity. Although that capacity is not sufficient, the Special Master did cover that as well as the department. We do not have sufficient capacity to handle all those labor tenant matters. Where capacity gaps have been identified, Honorable Chair and members, we then employ what we call a staff optimization process, wherein we then allocate resources where there is higher demand. This is the process that, unfortunately, due to budget cut, we had to try and implement those measures to ensure that we continue to provide the services that were required to provide, despite these extensive budget cuts of over 260 million that we suffer as a result of National Treasury measures that they've implemented. So, Honorable Chair, you'll notice that the highest number of practitioners allocated in KZN, about 11 of them. Mpumalanga as well, we've got 11. So the allocation is in line with the demand in these 2 provinces. And obviously, based on the demand, then we'll then try and find the resources to reallocate resources. But we can only do so much, Honorable Chair and members, because our budget has been cut by about 260 million. Even if we try to rationalize the staff, that's how much we can do. We cannot go beyond what we have internally. Honorable Chair and members, considering the large number of outstanding labor tenants claims that must still be processed by the department, it is anticipated that number of labor tenant matters could increase, which will mean that legal aid will need additional budget for internal legal practitioner position, as well as for allocation of some of the matters to the Judicare legal practitioners. At this stage, Honorable Chair and members, we only allocate to Judicare looking at our resources within the budget, but also only in instances wherein there is conflict of interest. So because of our limited budget, we only allocate instruction to Judicare where there is conflict of interest and when the budget does allow for that. If we then move to slide 31, where we are now dealing with the issue of disbursement cost, the funding shortfall relating to the disbursement cost. We'll start with the expects witnesses, where the issue of just and equitable redress is considered for the claimant, which means that the claimant must present evidence on the value of the land rights. The only manner to determine this value is to appoint an appropriate valuer that is skilled in the valuation of such land rights. The cost of evaluation is approximately 80,000 per matter. This amount is influenced by the complexity of the matter as well. Honorable Chair and members, in 26-27 financial year, legal aid has a disbursement budget of only 850,000. This budget is for all land-related matters, including restitution as well as ESTA matters. So 850,000 budget for disbursement. In July alone, Honorable Chair, this year, a historian had to be appointed in one restitution matter. And this was at a cost of 500,000. This means that from the 850 budget that we set aside for all land matters, about 59% of the entire budget had been spent in one matter. 59% we spent it on one matter. This obviously shows that we do really need additional budget for us to be able to litigate appropriately in those matters that we have. Therefore, in order to effectively and properly present the claims of labor tenants, we need additional funding for expert witnesses, if we have demonstrated how expensive those experts can be. If we then move to slide 32, this is the travel and accommodation cost for consulting with our clients. Honorable Chair and members, although our local offices are situated strategically in town, as well as next to our community, our legal practitioners have to travel to where clients reside on the farms when they need to consult in order to eliminate the cost barrier for the claimant. So we do not request the labor tenants to come to our offices because they may not have funds to be able to come to our office. We go to them. More often than not, Honorable Chair and members, the farms are far from towns and cities where our local offices are situated, which means provisions must be made for travel and accommodation costs for legal practitioners for these purposes. Honorable Chair, I must mention that we do have sufficient footprint. Obviously, we may not have footprint in the farms. In total, we've got about 129 local offices across the country. But the farms are actually in the outskirts where we really need to travel. In terms of our budget, because National Treasury has not given us sufficient budget for land-related matters, in our budget, when we do the budgeting, our budget is to cover the cost for traveling from our office to courts. And as a result, Honorable Chair and members, we do need additional budget to cover the travel and accommodation cost when our practitioner had to travel far to the farms, because at some point, the distance is far and they have to spend hours traveling, waiting for the labor tenants to be available for consultation. Sometimes they have to sleep over there for them to be able to, so that they don't travel in the evening because the farms and the road are not that proper. The next slide, slide 33, we deal with funding shortfall relating to the travel and accommodation cost for the clients to court. Honorable Chair and members, the seat of the land court is in Randburg, which is the Gauteng province, and attendance at court is costly for our clients, which means that they may not be able to attend courts due to their means, as most people who are staying in the farms do not earn sufficient amount. And due to the nature of the land rights matters, it is imperative that land claimants do attend the court and hear how their matters are being adjudicated. We do sometimes provide and assist them to travel to the courts. However, we do need additional budget to be able to transport the claimants to go to court and be able to participate in those proceedings. And you see about the department, why the Department of Justice have got courts across the countries, because courts must be accessible by those who need assistance from the courts. But in terms of our land court, which is currently situated in the Randburg, the labor tenants do not have sufficient means to be able to travel all the way from the outskirts of our provinces here in Gauteng to be able to attend those courts. Therefore, it is difficult to estimate the budget required for clients traveling. We only have 4 years of information to work on. However, considering the average number of new labor tenants matters, which is currently at 212 per year, it is estimated that legal aid may require an annual budget for travel and accommodation costs in the amount of 952,000. This is only in respect of labor tenants only. We do have other matters, land-related matters that we deal with, but for labor tenants only, we'll need almost 1 million just for travel and accommodation costs for the clients for them to be able to attend the cost. This estimate is calculated on one matter being set down for 5 days and only one client attending the court proceedings. In most instances, Honorable Chair and members, our clients are actually communities, wherein it might be difficult to only transport one person because they may want to send more than one person to go and attend the court proceeding. So the figure that we're giving here is conservative estimate, and it's used for illustration purpose only. Honorable Chair and members, at slide 34, we have been requested to present the measures to accelerate the processing and finalization of the labor tenants matters. Honorable Chair, we start with legal aid as one of the key stakeholders in terms of the labor tenants claims. We looked at our internal processes and we have, Honorable Chair, identified inefficiencies in our own internal processes. And in order to address those inefficiencies, a standard operating procedure is being developed. And this standard operating procedure will prescribe our turnaround time for each step in the litigation process, because our job is much more of legal representation. And this will be introduced in this quarter, those steps that need to be done. And this will assist our practitioners to fast track the litigation stages that we implement. Another issue that we have identified internally is the alternative dispute resolution mechanism, which is the mediation negotiations. Legal Aid now has put measures in place to ensure that every labor tenants matter referred to court in terms of 16 is processed through alternative dispute resolution mechanism prior to litigation. In other words, once we receive the referral, we'll try by all means to ensure that we negotiate the settlement of the matters, as opposed to just taking the matter to court and litigate, because the landowners sometimes do delay and cause unnecessary delay in finalization of the matters. So in other words, what we're proposing is that as part of litigation strategy, mediation will be the first option. And if it fails, then the matter will then proceed to court. And when it's proceed to court, because we're now reviewing our processes internally, then the matters will not be delayed. We'll make sure that the rules of the court are complied with. In terms of any delays, we'll then be able to make sure that the court make enforcement of compliance with those timeframes that has been identified. So the two issues that we identify internally, those are the measures that we're going to put in place to ensure that we fast track the processing of our matters. Honorable Chair, there's been an issue with regard to the department referral of matters to the court. In terms of the department, we are proposing that the capacity of the department should be increased in terms of them processing those outstanding labor tenants claims, increased turnaround time for endorsement of settlement agreement by the DG, and also approval where settlement has been increased for the purchase of the land. You'll notice, Honorable Chair and members, that in the details spreadsheet that we've attached, there are matters that are awaiting the endorsement of the settlement agreement by the DG, which need to be fast-tracked. And also, lastly, in terms of the department, we propose that the turnaround time for Section 16 referrals should also be accelerated. We also requested Honorable Chair and members to present the measures to strengthen access to justice for labor tenant. In terms of the land court, and I think we highlighted earlier on in terms of the seat of the land court that is in Randburg. So we are saying, although the land court has a virtual hearings, sometimes some of our clients do not have access to online platforms. As a result, it is proposed that the land court should consider increasing physical hearings at court seat where clients reside, or at least closer to where clients reside. It is also proposed that the same approach should also be considered for mediation process, so that mediation process should also be take place at closer to where the clients reside as well. Honorable Chair and members, in conclusion, as a service-oriented entity, Legal Aid SA heavily relies on its staff for effective service delivery, and staff costs are the entity's primary expenditure. Currently, the cost of employment comprises more than 80% of the budget allocation. And as indicated earlier on, it has become difficult with the budget cut of 260 million in this financial year only for a legal aid to be able to function efficiently. Accordingly, Honorable Chair and members, appropriate funding for Legal Aid SA will assist the organization in improving its efficiency on service delivery, especially the protection of the labor tenants, who are one of the most vulnerable people in our country. Lastly, and to ensure continuous provision of quality legal services to our legal tenancy claimants, Legal Aid SA, as indicated earlier on, has introduced a quarterly performance review. So these are internal measures that we have, wherein each matter will be tracked and appropriate direction will be provided to the practitioner to ensure that all those matters are not unduly delayed, especially once the matter are in court. Thank you so much, Chair. That's the conclusion of our presentation.
Thank you. Thank you, Director General and your team. Thank you to Professor Lavin, the Special Master. Thank you to Legal Aid South Africa. Honorable members, it's now your turn to engage. I will still request the assistance of the secretary to identify hands. If you may do so. Can I list them down?
Chairperson.
Yes.
It's Honorable Mthethwa.
Yeah.
Honorable Adams.
Yes.
Honorable Dalani.
Honorable Dalani.
Yeah. Honorable Dalani,
Honorable
can you please mute?
Honorable Shelembe. Honorable Matiase.
Yes.
My head is up, Loz.
Oh, I didn't see, sorry. Honorable Nana.
Yes.
Honorable Isaacs.
Okay.
Honorable Mkhaga.
Okay.
I think on the platform, that's all hands I see. Honorable Maseko, did you raise your hand or am you can just put Honorable Maseko on your waiting list, Chair.
Okay. Thank you. Thank you, Lwazi. Can we start off with, look, honorable members, we have exactly 45 minutes to an hour if we are going to break it up 1:30 to engage and solicit responses also from the department. So, Honorable Mthethwa.
Thanks, Chair, and greetings to honorable members, greetings to the ministers, deputy minister, and director generals and DTGs and our committee officials. Let me read this. I'm directing to the professor mainly because this is a disturbing phrase that we pick up in the history. It reads as follows. Centuries, we looted their raw materials. Then we told lies that the Africans are good for nothing. In the name of religion, we destroyed their culture, and they are being made. And after being made rich at their expense, we now steal their praise through miseducation and propaganda to prevent them from enacting black retribution against us. That was the Jacques René Chirac, president of France. And then another one is Lord Macaulay. He said in the British Parliament, I have traveled across the length and breadth of Africa and have not seen one person who is a beggar, who is a thief. Such wealth I have seen in this country, such high moral values, people of such caliber, that I do not think we would ever conquer this country unless we break the very backbone of this nation, which is her spiritual, lit, and cultural heritage. And therefore, I propose that we replace her old and ancient education system, her culture, for if the Africans think that all that is foreign and English is good and greater than their own, they will lose their self-esteem, their native culture, and they will become what we wanted, a truly dominated nation. I wanted to read this verbatim so that somebody doesn't say I made it up. But this is what we find in history about the land dispossession that happened in our country and the entire continent. My question is this one. There is an error I've picked up in the 1913 Land Act narrative, which we are using as a reference when we address the issues of labor tenant, land disposition, and so on. And the error is, in 1913, when land disposition was enacted, the beneficiaries who are labor tenants and CPAs, community property associations, were not existent at that time, but Amakosi existed. But when you now do land administration and restoration and restitution, you defined Black people in a category that never existed in history, but you maintain consistency in addressing white people as white people, and you also name them as white farmers or commercial farmers, or private property owners. And then when it comes to us, we have different definition. But be that as it may, in KwaZulu-Natal, I like it that you say most of the cases are in KZN. I'm just using this as a reference. There is Leo Fontaine farm where there is a conflict of overlapping legislation in terms of labor tenant versus farm dwellers versus land claimants, because people were removed, eMadlangeni to be specific, in Utrecht, where I'm coming from. People were removed into Osizweni. And then the white people will bring their labor from the other provinces when they exchange hands and selling farms. They would sell a farm and decide whether they take on board the people they found in the area or they chase them out. And that results into eviction issues. So as we speak, in Leo Fontaine, one household was granted land tenure rights. The department gave them the land. They left out umndeni wakaMfusi. The Mfusi family, it is in Benstop in Utrecht. They were left out, yet they were staying together in the same Leo Fontaine farm. And the reason why they were left out, the white man decides who must be granted rights to that land, as opposed to people stating their case to say, hey, we were together with umndeni wakamfusi together, but only one was given. So I'm just citing an administrative error that occurs as a result of white people having an upper hand in determining who is a labor tenant, who is a farm dweller, who is a land claimant, and they all conflict in one area and nobody is ready to assist with the situation. When you look in 32 years, white people have benefited more in this dispensation in terms of land profit maximization. And yet this dispensation was meant that it will restore land back to Black people, but we still have cases. My question is, I saw something that you said there, the deceased claimants. This process is so long that it allows people to die so that the case can be closed under pretense that the people have died, those who made a claim. Why are we taking so long in redressing these claims as if we are dealing with technical issues, whereas we are dealing with warm bodies who are subject of natural causes of death and disability and so on? There are cases of child-headed families. When their elders died who lodged these claims, it looks like the case doesn't continue. And this is an attitude we are picking up from Treasury, that land is not a priority, yet we are dealing with Blacks who are previously disadvantaged. I want to ask Professor, how does the Expropriation Act court case that has been opened by AfriForum and DA affect your execution of your work? Because whilst you are trying to establish systems in place to redress the imbalances of the past, the same white people whom we are dealing with in the procedure of returning land, they are busy challenging the same laws as if their laws in 1975, when they expropriated land of Amakosi, was better than a constitutionally elected president signature signing Expropriation Act into law. They challenging that as if they are better off than the current president. These are clashes in law that we are picking up that we need to actually determine. But let me go and say that why don't we decentralize the function of this court? You can't centralize a court in Gauteng and yet you are addressing matters in Utrecht. Then people have to travel. And the people who don't have the money to appeal or to petition the court are the same who were dispossessed. The white people who are dealing with, they've made money over time. They continue to make money at our expense, and they challenge these laws every now and then as if they have a right to do that. And the question is, why are we giving them an upper hand above actually Black people? But that is what happens when you take the law of a colonial master and you hope that this law is now holy and you can actually be able to find recourse in it. There is no recourse. It is an unjust law, and an unjust law is no law at all. Thank you.
Ale, can you hear me? The next one would be Honorable Adams.
Thank you very much, Chairperson. My greetings is to all members on the platform and protocol observed. Chairperson, I will go straight to my questions. Can you hear me?
Yes, Honorable Adams, you are audible.
Thank you very much. My first questions will go to the department. Backlog of 8,957 labor tenant applications. The department report approximately 8.957 outstanding applications, many affected by court referrals, disputes and capacity constraints. What is the department's year-by-year plan and final target date for eliminating this backlog, and how many claims does it realistically expected to finalize during the 2026 and 27, 2027 and 28, and 28-29? And then the second question, why are 103 of the 302 court referrals still not allocated? The presentation shows that 302 cases have been filed at court, but only 199 are under case management, leaving 103 not allocated. What specifically is preventing those 103 cases from being allocated? Who is responsible for resolving the backlog? And by what date will the 103 be placed under case management? And then to the Special Master Chair, the central concern is that after 3 decades, 8,930 of 20,524 claims remain unsolved, while even the department's figures on finalized claims inconsistent. And then also to the Special Master again, LTCRC built and approved, but still not operational. The question is, who is responsible for the completing data cleansing, mitigation, testing, and CAB approval? And what are the specific deadlines for each step? And my last question to the Special Master, why has the Northern Cape not finalized a single one of its 11 labor tenant claimants? I thank you, Chair.
Thank you, Honorable Adams. The next honorable member would be Honorable Ndalane.
Thanks, Chair, and good afternoon. I'll start with the court processes and legal. And my question is that what criteria does the Special Master use to declare a case court ready? The second one, what legal support is provided to labor tenants' family during court proceedings? And when it comes to challenges, what are the top three specific challenges that continue to delay finalization of labor tenants claim despite court supervision? Thank you very much, Chair.
Thank you, Honorable Dalane. The next honorable member will be Shalembe.
Thank you very much, Chairperson. Chairperson, mine is not that much, but just a concern that is being raised around the legal aid South Africa, that they are facing, the issue of the budget cuts and resulting in reduction, especially being able, to get, enough staff to do their work. Now, I'm just checking, although the minister is not here, that how do we address the situation? Because we can speak a lot, but if there is no funds to do the work, what next? The department is planning to do. So if the department can give me an answer on that, if there are any promises that they will get the funds to assist the Legal Aid South Africa. And it's very, very worrying looking, to the backlog, because if, you look at it, it's affecting, the rights, of the tenants, also, creating more problems when it comes to the backlogs, and with the high loads of work being given to few, people expertise to do their work. My question is there any plan to address that, the issue of funding? Thank you very much, Chairperson.
Well, thank you, Mshalele. Honorable Matiase.
Thank you so much, Honorable Chair, and greetings to colleagues, the Portfolio Committee, the officials, and from the department, representative of Legal Aid South Africa, Professor Levine and his team. Look, Honorable Chair, there's a point that Prof has raised. But before I deal with that, let me quickly state the following, as I join my colleagues in making some contribution. Honorable Mthethwa makes an important point, and drawing reference from history and all of that. The problem between the apartheid dispensation, Honorable Mthethwa, and the democratic dispensation is anchored in the nature and the substance of the constitution that governed both dispensations. The apartheid dispensation was based on parliamentary supremacy, and our democratic dispensation is based on constitutional supremacy. That's the significant difference. And the second point is the constitution as it was adopted in 1996 celebrated as one of the best constitutions in the world. No any other country in the world has such a constitution but South Africa. And you ask yourself why South Africa has such a constitution which exclusively here in this country, and all other countries in Europe and anywhere else do not have such a constitution. And while this constitution is celebrated as one of the most advanced constitution, unfortunately, alongside this constitution, no deliberate, adequate measures were put in place to establish institutions and systems that corresponds with the constitution. So you've got a good constitution as is said, and you've got a bad governance institutional mechanisms. And this is the point I want to come to, which has been raised by Professor Levine, that the three arms of the state have got to act together. And that's where the problem is. The three arms of the state are not acting together. They're acting in conflict and in antagonistic, competitive nature. As a result, there would be no progress, not only on matters that concern land reform, specifically matters that concern labor tenants. We've got a weak state and weak institutions. You've got a biased judiciary. We've got an ineffective executive. You've got a legislative such as parliament, which we sit in that parliament, which is toothless. And we may mention all the problems and we may ask all the questions in the world until we turn blue in our face. The Professor Levin, his heart and mind is at the right place. He wants to find solution as directed by the court. But the poor professor is hamstrung because of the disconnectedness, the misalignment, and lack of commitment and political will and legislative will from these different arms of state. We may ask why and how many cases are yet to be ready for court adjudication. We may ask why the process is so slow. We may ask why the legal aid in South Africa is not ready to help where it is required to help. All of this is because of the misalignment between the arms of state and lack of political will by those who are presiding over these arms of state. Now, we're going to be in these discussions for the next 5 years until the mandate of the special master comes to an end. We'll be still in this place unless something drastic is done. We'll still have arrogant political parties that are challenging the Expropriation Act because they are the ones who have imposed the constitution on us. And they know how to manipulate the very constitution. Now, I'm going to say this and it's just unfortunate it had to be said. Until that there is a total overhaul of the state, total takeover of the state by a progressive, egalitarian government, will still be where we are and will still be crying crocodile tears, pretending to be doing something on behalf of labor tenants, and cry as much as they cry and ask as many questions as they ask, but failing to provide answers to those questions as elected public representatives until something drastic, fundamentally changes in this country and something gives, and something must give at some point. We'll still be lamenting about the plight of all the labor tenants. Their list is endless. I may mention here, because he keeps on knocking on me, he keeps on calling Mlungisi in Mpumalanga, the labor tenant there. But I've got no answers to his questions and his level of impatience. And I guess no one has got answers to him. Is there anyone else here who's got an answer? Perhaps that's the question that I must ask the department, Mr. Zulu. I must perhaps also ask Professor Levin. Do you both gentlemen have an answer for Mr. Mlungisi? That's the only question perhaps I can ask. Thank you so much, Honorable Chair.
Well, thank you, Honorable Matthias. May I actually call upon the Honorable Nana to take the floor.
Good afternoon, colleagues, and thank you very much, Chairman. I will really reserve my questions to. I will postpone them to a date in which the minister or his deputy will be present. But can I just mention this? I hear colleagues accusing other political parties of being arrogant for one reason or the other. Going to an extent of accusing the judicial of being biased. None of the political parties, or shall I say, the majority of the political parties represented in parliament have, at one stage or the other, approached the courts. That on its own is an indication of confidence in our courts. But now that some of the findings of the courts are not in their favor, they find it easy to throw mud at the very last line of our defense, which is the judiciary. I will stop at that.
Thank you, Honorable Nana. Honorable Mkaka.
Thank, Honorable Chair. Mine too, I'll be too short. Because here it's clear that we're revolving around, we're moving in circles in dealing with this question. These are very old cases. The backlog is too huge. And the intervention is only in two provinces, KZN and Mpumalanga. And the question is, what is happening with other provinces? What's happening in other provinces? We see the focus of the report that they've identified two provinces, KZN and Mpumalanga. My interest is to understand what is happening in other provinces. Lost claims. I think the department must elaborate more on this question of lost claims. We hear the stories, the involvement of NGOs that contributed to the losses, and the centrality of courts in the land redistribution is what is being elevated by the report. Because the pace of delivery seemingly is determined by courts as of now. Was a backlog stuck in all these courts. I know that what is called land courts, but I don't think is sufficient in terms of dealing with these backlogs and other cases that are not yet resolved. Don't you think that we need a special dispensation just to wipe out the backlogs? Somebody talks about the decentralization of the land courts. I mean, I'll be talking of special land courts, clustering provinces so that you fast track this process of resolving these backlogs. What then becomes the opinion of the department as far as that? But this question is more relevant to the minister. Somebody must respond as to what then becomes the opinion. Instead of wasting time and resources trying to deal with cases where exactly we know that these cases are stuck because courts are overwhelmed, judges are overwhelmed by a huge task in front of them. Why don't we establish special courts to deal with these backlogs? 2, 3, the question of capacity of offices, OVG office. We thought that OVG office is going to simplify matters for us, but seemingly is under attack to the extent of being undermined. And I know that it has been reported to the committee that capacity is the issue as far as this OVG office. To the department, what capacity are you building to strengthen this office so that this office assumes its rightful position of determining if value and prices for land in this country? What efforts are you applying in ensuring that this office is strong and is able to contend with all other processes that are a problem today? The last one, because I'm jumping many of my comments because I could see that the challenge posed by the DA and Freedom Front, challenging processes around a constitutional agreed process by all of them is worrying. But it might give us an opportunity to reopen some of the clauses in the Constitution, and if that is the case, whilst we are dealing with this matter in court, why don't you reopen some discussion in other clauses that are a problem to the Black majority in this country? Because I agree and I fully share the sentiments that the Constitution is the best Constitution because it has managed to protect white privileges and rights at the expense of the Black majority. And therefore, it must be seen to be a Constitution that addresses the problems of our people. It's more than 30 years now, grappling, moving around technical issues, because now this process is too technical, and I raised this issue, that this technicality irritated the former president of Zimbabwe. Hence, he made that decisive move that nearly compromised his country as he was intervening. But seemingly here now, again, we're grappling with the same process of dealing with these technical issues instead of returning the land to the rightful owners in the country. It's just a comment, Chair, that these backlogs are worrying and they're piling up, and it's clear that there's no solution in the near future unless the minister change the gear and begin to be decisive in dealing with some of the aspects as far as this question of land is concerned. And I think the minister must be called to lead this particular process so that we look for easier ways, because there is a solution in all these problems, but we're tied up by this provision of the Constitution. Somebody must unlock these blockages so that we're able to make progress. This committee, I'm definitely sure, as well lamenting for the last previous portfolio committees that were handling the question of land. Again, I foresee that by the end of this term again, we'll have moved in addressing the question of land. Can you make a breakdown per province of all these backlogs? Can the department make that breakdown per province for all these backlogs so that we are able to quantify the cost per each province as far as this question is concerned? Thanks, Chair.
Well, thank you, Honorable Khafa. Honorable Isaac.
Thank you very much, Chairperson. I'm sorry for the fact that I was now kicked out, but it was on this side where for a moment there was a drop in the electricity. But fortunately, I'm back. I'm still so disturbed by that, but it's fine. So, Chairperson, I think a lot have been said by all the members that spoke before me. And I was looking at the issue, and there is a trend that is throughout all the presentations, and it is the issue of budget and capacity. That is actually the reason why we are sitting after so many decades with still a backlog. And I actually calculated the number of days that it took to deal with almost 2/3 of the claims that have been there. Now, if this amount of claims, say a little bit more than 11,000, almost 12,000, took this amount of days, about 10,900 days, how long will it take to finalize the outstanding issues? So I think by now we should have been, particularly the executive should have been thinking out of the box as to how we deal specifically with this specific issue, how we make sure that we have reliable data, and then we appoint a specific focused group to deal with the specific issues. Because it is about budget, it is about capacity. So why don't we then make sure that we bring together all the available capacity and all the available budgets in where it is lying in different areas, bring it together and make sure that we deal with a specific issue. If we have to give the money to the department, or the department should give the legal aid the responsibility of, or give the special envoy the responsibility, but something needs to be done. We can't be listening to the stories over and over and hearing the same stories about budget and capacity. Where is the commitment? Because I don't think we can speak about all the things now. We have all the issues. It's about traveling, it's about accommodation and what. Why is it that no one ever started to say we are decentralizing the process? We send a team in, finalize the issues in one specific province, or send 2 teams, finalize the issues in 2 specific provinces, and get just to a point. Because for us to repeat now what have been reported and to ask questions about it, we are not at that point anymore. It should be the Treasury, together with the department and together with all the stakeholders, have to sit together and come up with a solution that is a feasible one and that will work and that will assist us. Because it is actually very concerning and deeply disturbing how we have been hearing reports about issues that seem there is no remedy for these issues. Although it is not necessarily the case, it's just that there is a lack of urgency, possibly a lack of commitment from whoever must make sure that this becomes successful. So I just thought, let me make this observation without asking a lot of questions, because there are so many programs and there are money in each of these programs. Why is it not that at one stage or another we decide to coordinate this areas of responsibility, bring it together and make sure we finalize it? Chairperson, I will stop there because I'm also looking at the time. Thank you.
Well, thank you, Honorable Isaac. The last one would be Honorable Maseko, even though I did not see your hand. Is she on the platform?
Yes, I'm on the platform, Chair, and good afternoon, and thank you very much. I think I attended, Chair, to just listen, but if I have to make a comment, is to say You know, we need to remember this department is the Department of Land Reform and Rural Development. And if we hear the message that says that the capacity and the budget, when you look at the department that has been underspending, and when we say capacity, when everyone, even ourselves, we say capacity within the department, what do we mean by the capacity? Because we need to unpack the capacity. You can say that what is needed from the department for us, you can see the changes that have to happen in dealing with the backlog of each and every program that is within the department. Because there's no way where we see a branch that is shining. All the branches, they're underperforming. Now we have to go back as the oversight component to say, department, just tell us when you always talk about the capacity. Give us the interpretation of the capacity based on what is needed. Then we'll be able to can say what is needed. We'll never run to the treasury about the department that underspends. It's going to say to us that we don't know what we are doing. Let's see what is it. The commitment from the officials is there for issues that have to be dealt with. Are they implementing what needs to be implemented? All these commission, the reports that were commissioned, are they looking at that to see if they can act accordingly? We need to relook at this department as a whole and say that the intention is really being activated, or there is a redundancy of issues that have to be dealt with before they can say they are activated as the department, since they moved from the Department of Agriculture, because the backlog is saying that there's no agency within our officials. I think that's the only thing that I can contribute without repeating what all the members have said, Chair. Thank you very much.
Thank you, Honorable Maseko. Well, DG, you have at least 15 minutes to respond to the questions, because honorable members, they largely made comments and expressed concerns rather than actually ask specific questions. So 15 minutes should be enough. Thank you, DG.
Thank you very much, Honorable Chair. Let me appreciate the comments and the questions that have been asked. Chair, just on two areas. One, on the data cleansing, we have now tasked the Surveyor General together with the DDG responsible for spatial development framework, which is SPLAM, to provide support to data cleansing on this program. So they will be working very closely with Prof as part of how do we improve the data cleansing verification so that we can start moving these cases. The second part is that the court have already directed us to meet with the justice, and part of that discussion will also include engagement with Treasury around the funding shortfall, specifically for the special master and the program in its entirety. And the issues around legal aid funding will also be discussed at that level. I thought, let me just those high level, but if you allow, Chair, can I ask Mr. Zulu to respond to the specifics areas that have been asked? Thank you, Chair.
Thank you, DG. Mr. Zulu.
Thank you, DG, and thank you to the members. I'm going to talk about only two key areas. I think maybe Prof. Lavin will talk to the Nkambule matter that was raised by Honorable Matthias in terms of how far. But mine, I'm going to address this issue, although DG has alluded to the meeting with Justice, but the schedule that I have presented before the committee, those hearings from the land court, they are not going to be happening in Randburg. They are happening in provinces. What the land court has done, they've given us the schedule. They are using community halls in municipalities, whether a school or a magistrate court or a high court in a province, so that is closer to the labor tenants to attend. So the one that would be in Mpumalanga, they are looking for a local place, a venue in Emelo or under Gersibande. So that is what the court has done. I think maybe legal aid will need to engage with the secretary of the court, because that is the process that was agreed. So they are not expected to do everything they've decentralized. If it is KZN, they will go to the nearest venue in KZN for communities and applicants to come closer. Then the issue on the targets, we will provide by Honorable Adams will provide that. We have it. And on the issue of raised by Honorable Mtetwa, we are aware of that matter of Mr. Mfusi. His family is a former EFTA occupier. The state bought the farm for the labor tenants. That matter is being dealt with by our provincial office in KZN. We are aware of it, but there is just a dispute between the former occupier and the labor tenants, Mrs. Ndlonzi, who was given the farm, and other labor tenants. That matter, because the graves of Mrs. Mfusi, they are there on the farm. They are known. They know her. That is the matter that is being dealt with by KZN. I think let me stop there, Chair, not unless, or the breakdown on the backlog cases. We have the list. We will also engage with legal aid. Remember, all those backlog cases were handed over to legal aid in 2001, the old cases. But the new cases, we will be able to provide that information. I think that is the issue that was raised by Honorable Mkhaga. Thank you, Chair.
Thank you, Mr. Zulu. May I hand over to the Prof?
Thank you very much, Honorable Chair, honorable members. There's two sort of kind of broad questions. The one deals with, the issues of backlogs and so on. I'll say what I can about that. But there's other ones which are trying to, from Nyamboso Kyle, I'm being asked to sort of go a bit deeper there. So I will try and answer what he's asked me to answer. The first thing is, it's true that the classification of labor tenants may or may not have existed in 1913, but the practice, the social relation of exploitation, the way in which farm labor was used was a form of semi-slavery which persisted right up until the latter part of the last century. And that is, people did not receive wages in return for their labor. They received access to land. And that land was in areas that were classified for white occupation from the Union of South Africa, although it already existed in the four republics, or when it weren't all republics, but the colonies, if we can put it that way, and the independent Boer republics at the time of the Union of South Africa. So that is the form of labor exploitation, which really, even till the present day, exists in one form or another. So you might find the existence of wages, but they are extremely, extremely low. And in return for that, there may be rations, there may be access to grazing land, residential land, and cropping land. Of course, there's been a massive cutback on grazing land. And the most reliable survey that has been done on the condition of farm evictions, as the book title is, was presented in Parliament in 2005, which shows that between 1984 and 1994, 2.7 million Black African people were displaced, removed, forcibly removed from farms, and the number rose to 3.3 million between 1994 and 2004. And I did make that presentation the first time I came to this committee. So I'm not really going to necessarily go through it again. But there is a legacy which Honorable Matiase as well as Honorable Mtetwa have sort of put at me. It's true. It's true that there is a legacy, a colonial legacy, an apartheid legacy. There is a colonial unconscious, as Frantz Fanon called it. Because Frantz Fanon said, when you inherit the state at independence without changing it, then colonialism comes back to bite. And in a way, that is, in a very simplistic way I'm putting it, is what we face in this country. Even on the issue of land expropriation, which was thrown in my direction. You see, Labour Tenant Act is law of general application. That's what it is. You don't need the Expropriation Act to expropriate land to resolve a Labour tenant claim. You don't. You could even, if you were able, if lawyers, because this is now lawyers, it's not the state that's going to do it per se. The courts will do it based on the arguments of lawyers. If lawyers come and make the case in a certain way, then expropriation can occur and has occurred in the history of case law. But the history is very thin because I'm sorry that I always have to remind the honorable members of things, because I've also tried to set a positive tone in terms of the work I'm doing with the DG and so on. But 9,000 of the claims, as testified in court by the DG at the time, were resolved using land redistribution and land restitution mechanisms, which meant what happened is that farms were acquired through Act 126 of 1993, and these were then given over to labor tenants and farm dwellers in CPAs or whatever the governance form that was created on the ground at the time. So when we're talking about cases actually going through court and those processes, the numbers is very low in terms of the very low numbers already being identified, because there was a question as to why are the other provinces behind. Well, the other provinces are behind is because of the claims lodgement process. There's some kind of a feeling that it's only KZN and Mpumalanga had labor tenants. Of course, there were particular interventions in the Boer republics and the colonies, Cape and Natal, which undermined that form of labor exploitation, particularly following the abolition of slavery. Although this kind of labor exploitation only exists in form rather than substance when it comes to slavery. So, yeah, I mean, who cares, you ask, Honorable Matiase? Well, there are people who care. And like you say, I might be isolated, but I do have a level of confidence now that we are going to be able to deal with matters, because all the years prior, I've been telling you that I'm not telling you anything new today, because these systems were created and evolved over time in the case of the data system, the labor tenant claims resolution system, to actually be formally endorsed by the EXCO, because that's what the DG told me at the beginning of 2024. And then by the end of 2024, it went through the EXCO with all the necessary documentation to be approved. So, but even then, nothing happened, because I heard the Northern Cape mentioned. I got a report last week from the Northern Cape, which was indicating that they are preparing all these matters for court. And the question was posed, are you using the court referral framework? And the answer was no. And I've told you, I am unfortunately convinced that when I get to Limpopo, I will find the same. But I will reserve my judgment and report when I come next time to Parliament as to whether, in fact, those numbers of matters coming from Limpopo are being guided by the court referral framework. Because that is really what is required. Otherwise, there will be logjams in the court. So yes, there are challenges, but there are solutions now. And it's up to those of us who are responsible, principally myself and the DG, to make sure that we implement the solutions and move decisively towards very systematic implementation. So, yeah, I mean, I am saying that, you know, there is an issue of the relations between landowners, labor tenants, and farm dwellers, which we can't really dismiss and push aside. By the time you get to mediation, by the time you get to court, the balance, the playing fields are still not level, because we're scraping around for pro bono lawyers now, legal aid struggling to get itself going at a level of scale and mass claim resolution and so on. And so when people walk into mediation, even if they have legal representatives, and I've witnessed these things, the playing fields are not level. And the playing fields need to be leveled so that really people who are the rightful owners of the land in terms of the law now, as it stands, the Constitution and the Labor Tenant Act, we have rightful landowners who simply are not recognized, but continue to be abused, like Mr. Nkambule. So I will still appeal to legal aid, because, you know, I've been taking this matter up with them and I never get a response. I've written formally, okay, via the Newcastle office with a request for Mr. Nkambule's duty care to be reinstated. In the process, I was told, well, the criteria insofar as reinstatement are concerned would be met by Mr. Nkambule's case, because he has, in fact, or the matter, in fact, was being at the point of pre-trial discussion. So I think that's all we can say for now. But otherwise, with Mr. Nkambule, we will work with what we have available, which is going to be the legal aid attorney who's dealing with, you know, so many cases which are unrealistic to expect any human being. I have nothing against that man. I've discussed it with him. He's obviously trying to do his best, but it's impossible for a human being to handle over 60 cases. It just makes no sense. And those are old figures, by the way. The number of cases that office has to deal with in Newcastle, because Wakkerstroom does fall under the Newcastle office, albeit it's located in Mpumalanga, it's just not practical for those attorneys to be able to deal with the cases properly. So, yeah, I mean, I think it's important what Mr. Zulu has explained about the manner in which the Land Court will be operating. It is turning itself into a court of the people. They're dealing with mass case management of restitution matters. They are doing everything in their powers to bring in additional judges, acting judges, to increase the capacity of the court to turn things around. And I think all of us who are on the other end of the process, which is the department end, we just need to pull together and make sure that we do pull together and stop competing with one another, seeing ourselves as a counterpoint to the other, and work together, because, you know, people are dying. That has been mentioned. People are dying, and it's happening all the time. And we have to make sure that when people die, they die confident with the knowledge that their families will inherit the rights which they have earned through almost forced labor for centuries. So, Honorable Chairperson, I've tried to answer some of the questions. I would be available if Honorable Nyambose wants to contact me to also engage with the department at ground level on the matter of Leeuwfontein to try and understand it. But I guess Mr. Zulu also did clarify that, because that's part of what the special master has to do. You know, there are numerous complaints which come our way, and we do try and engage, get to the truth, and see how we can activate the department in terms of finding sustainable solutions to them. Thank you very much, Honorable Chair and Honorable Members.
Thank you, DG. I hope you're done with the responses to the questions and comments made by ministers or by honorable members.
Thank you very much, Chair. We done.
Well, thank you very much, DG. Well, from my side, I do want to say a big thank you to Professor Lavin for his insightful report. Indeed, his independent reports do assist us to do our constitutional mandate, that of oversight over the activities of the department. Thank you so much, Prof. Siyabonga kakhulu. Thank you. DG, obviously you are having your hands full, as you may see. Of particular concern to me is the lack of funding for Legal Aid South Africa, which actually has created this kind of, or partly created the kind of backlog that we're talking about now. I was just wondering if it was not possible for the DG to apply for some kind of a special dispensation for funding in order for you to fund the labor tenants litigations, actually augmenting Legal Aid South Africa. Because unless we actually unlock that and address that specific problem, we are ever going to be talking about, you know, pending cases, I mean, case backlog and all of that. I was just wondering if the DG, whether it is not possible for the special dispensation for funding of labor tenants litigation. And the second point that I wanted to raise is the issue of capacity. You see, there is, from the comments made by honorable members, and indeed some reports, actually there is a thread that runs through all the contributions that have been made and others that actually have been made previously, that of capacity, lack of capacity in the department. And I'm not sure whether there is a specific program to actually address the issue of lack of capacity in the department. If there is no program, and I would really ask that the Director General actually give that matter a special attention, because we are forever, ever since we came here in 2024, we were actually confronted with a situation where in every branch, people were acting, and in some entities, very key entities, people were acting. So I just wonder if there could be a concerted kind of focused program to deal with issues of capacitating, the branches of the department and their entities. But before doing that, perhaps it might also help to undergo a vigorous performance audit in terms of, what you're having now, the skills that are available now. So that when you start, addressing the issue of lack of capacity, you know exactly what kind of skills you're looking for. Because sometimes when we do our oversight visits out there, you get a sense of people who are just clueless, who just don't understand what is it that is expected of them. So perhaps the performance audit would actually help to address that specific area of skills shortage. And my last point would be to identify. I agree with honorable members that we have very little to show 2 years after we actually have been part of this committee in terms of what has actually been achieved. So my fear is that the term is going to, we'll get to the end of the term without actually anything tangible to show by way of our achievement. So we would need to embark on an exercise also with the department to identify low-hanging fruits that can actually, something that can be achieved and for our people. Yeah, that's how I can actually, make my own concerns, actually register my own concerns in the whole scheme of things. Honorable members, I do want to thank the department, thank the Special Master, and thank Legal Aid South Africa for their contributions. Thank you so much. Honorable DG, honorable members would appreciate to get the department's report, departmental report on Friday, so that they could actually have at least ample time to go through the report and make meaningful engagement in our meetings. So they are concerned that they receiving, the report of the department far too late for them to be able to prepare themselves for the meeting. So on that note, thank you so much, DG and your team. Thank you so much, Professor Lavin. And thank you so much, Legal Aid South Africa. Honorable members, can we move on to the next item on our agenda? Well, we already have passed 1:30, but if we could just spend 2 minutes or 2 minutes or so on the agenda, on the adoption of our minutes of our previous meeting. I hope that those minutes were actually circulated, and I will recognize the hand that would, the hand that is up for the adoption of the minutes. Honorable members, can we adopt the minutes of our previous meeting?
Yes, Chair, it's Mlindi Nana. I move for the adoption of the minutes.
Okay, thank you, Honorable Nana. Any seconder?
Honorable
Maseko
Ndalane, second.
seconder.
Thank you, Honorable Ndalane. Honorable Ndalane, seconds the adoption of the minute. Can I give Mr. Ben just 3 minutes to give us an update on the preparations for our study tour?
Good afternoon, Chairperson. Afternoon, honorable members. Chairperson, I think it was last week, yes, Chair. I did liaise with Mr. Mahafta and Mr. Crowley in regards to our oversight study tour, Chairperson. And they indicated that in India, it's currently a recess now. And then they will come back to me after this week. But tomorrow I'll just send an email tomorrow or Friday just to check up the status. But they did indicate that they will come back to me, but they have circulated the proposed dates to the Indian, to our Indian counterparts, Chair. So we are still waiting on them, Chair. So I will wait for them to liaise with me, Chairperson. But I think tomorrow or Friday, I'll just send a reminder just to check Uguti, where are we with our Indian counterparts, Chair. I thank you, Chair.
Well, thank you, Loazi. Is there any honorable member that would like to make a comment regarding the report that we've just received from our secretary? Just 1 minute. Okay, thank you, honorable members. In the absence of anyone wanting to make a comment, may I declare this meeting adjourned? And thank you, honorable members, for making yourself available for this meeting. It was indeed quite a fruitful engagement, but very, very concerning in the sense that we seem to be running in the sand insofar as, issues of land are concerned. Thank you so much, honorable members.
Apologies.